courtroom, she always picks bending the rules. She know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey, folks, welcome to day 106. Oh, I thought last week was mayhem. This week has been really, well, I mean, I can't even say interesting, because this is beyond what I assumed would happen after last week. After last week, I assumed Judge Whitaker would come back early this week and, well, motion is denied, let's move forward, blah, 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 blah. Monday changed that. Do I still believe she will deny the motions to dismiss? Yes, sadly. Should this trial be thrown out? Yes, but that is not the reality here. That is not the reality here. But after Monday, I do believe we are much closer for the judge to even consider dismissal with prejudice. But as I said yesterday, I think her choice is not a threefold. It is not dismiss with prejudice, dismiss, or move forward. It is either we move forward or we dismiss with prejudice. I think that is where she is, and she needs to reach that level. And after yesterday, after prosecutor Love's absolute, what a fuss o'clock. What a fuss o'clock. After what she put up in defense for getting herself disqualified, her reaction when Judge Whitaker said that, oh, that disqualification thing I denied, that was only for you needing her as a witness. When it comes to Brady violations and candor to court, oh, disqualification is definitely on the table. And the sheer fear that was on Miss Love was amazing. Amazing. And then she put up a bunch of witnesses. She thought, these people will make me look good. They didn't. But earlier that morning, we had Attorney Melnick, and I mean, he said what he was supposed to say. Then came Miss Bumpus. Oh, could have done better. Could have done a lot better. Could have done a lot better. And not the information I thought we would receive, but still confirmed most of what the defense have said all along. And yeah, I will not speak for Miss Kayla Bumpus, but if it were me, I would have been much more prepared. Much more. But we have to recognize that Miss Love is an excellent interrogator when it comes to confusing the witnesses. You have all seen it with witnesses. If she likes you, she just lets you tell your story. If she doesn't like you, she will jump in between, ask weird questions, vague questions, everything in her power to get you off your tempo. So I don't blame Miss Bumpus for the way it happened, but at least I would have become much more prepared, and probably with a lawyer. Christine asks, when is the jury coming back? At earliest tomorrow. Today, I do believe, I don't know if Miss Love will call more witnesses. I don't think so. Will we have a ruling from the judge today? I hope so. I don't know. If she doesn't, it means that she's still considering the extreme of dismiss with prejudice. I do believe that is what keeps her from ruling on the last motions. Jar is here. I was expecting 8:45 start today, but neither Miss Sylvia or Lan and Krim have started yet. I would assume the jury will be back next week, and they will have either Wednesday, Thursday, if something new comes up. But I do believe in order to resume Woody's testimony, they are not far from done. But then it comes, who else after Woody as witnesses? Will they make time to make these evidentiary hearings regarding the next few witnesses? And according to this, Judge Whitaker, yeah, that is her signal. She wants everything litigated before the witness takes the stand. Refreshing. Still no stream. It seems like they are beginning at 9 a.m. Let's see who's here. So Fun Size, Diogo, Gwendolyn, Lori, Didi is here. Christine, Republic Room, W Mug, Gwendolyn, Eric Rose. Time is on our side. Harris Rivers Show, T42, Lady Draconis, Jiggy, Auntie M. Yeah, Yar is here. Yar. Louis Thomas, Eric Rose, I think I mentioned. Bryce Sakes, it's Trinton. Okay, those are the ones of you who are in that chat at the moment. Well, what are our guesses for today? Well, if Judge Whitaker doesn't make a ruling, there will be evidentiary hearings today. Either they will conclude when it comes to Woody, and then move on to what else is coming forward if Judge Whitaker doesn't rule dismissal with prejudice. But also, now when the defense knows that, oh, disqualification is still on the table, let's find more stuff. So that can be it. Liam, is there a meetup when you come to the Atlanta? I haven't planned a meetup, But I mean, I know. I hope I will be out for drinks with the dog. I don't know in what shape or form that will be, because I will be driving in to Atlanta on the 14th and I will leave on the 15th. That would, I mean, on the 14 after court, maybe something. I don't know. I haven't planned anything. Is Miss Love going to have pants on today again? Yeah. That hotel with trying to, every time she is really nervous or try to get away with something, she does that pulling down the skirt thing in excess. See, still no stream. Let's see if there's anything on. Checking Kathy's. Dun, dun, dun. No, nothing. Nothing. No. Well, nothing that says anything about they are going to be late today. So, hard to say. Where are my nicotine pouches? Might be in the suitcase. Hold on a second while I go get my nicotine pouches. Let me give you some. Hello. Let's lower that for a bit. Liam says the line for mistrial is around plus 1250 for disqualification, even money. Yeah, I mean, that might, because as I had a discussion on Twitter yesterday, we know, I mean, there are 3 more assistant district attorneys on this prosecution team. That might be the remedy for Judge Whitaker to apply to the prosecution. You have 3 others. Congratulations. You are now trying this case. Or Tony Willis has to. So, yeah, I mean, yeah, overall it's lower odds on the disqualification, but it is a really high bar. It is a really, really high bar. Prediction poll about this trial. Sure, I can. There. And a misspelled, of course. Yeah. Will there be mistrial? And the options are yeah, no, or during the cross-examination of Woody. Because you all know the defense will ask him, Woody, did you end unalive Donovan Thomas? And if he pleads the fifth, oh. Do I believe he will? No. Not during that. They will just say no. Liam says, for as much crap as Dia Willis gets, she's a very competent litigator. She would not have ran this case this way. This is Fannie Willis' case. She handled everything up to trial. She was involved in pre-trial hearings. So she was very much involved in this. So this is her case. It's just that Ms. Love is the main litigator for it. This is Fannie Willis' trial. Nice music. Thank you so much. I do it via Artlist. And the song is called Skogsdrömmar, Forest Dreams by Black Bar. Oh.
Alleged violations of the... I believe, correct me who I'm...
Let's see if Infamous Sylvia's is on. Let me just pause that one. Okay, so we are going with the lawn and crim, but for now. And let's do this one. And let's see what they say.
Correct me who I'm wrong, but I believe that Ford is being proffered to support the position that alleged violations of the rules of professional responsibility are sufficient to support disqualification.
What?
For a couple of reasons, Your Honor, I just asked that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Redaction, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. So that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify. And if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shart's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shart's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shart's amended motion for a fair trial. So
That filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay.
They haven't replied to the supplementals.
All
Wow.
right.
That is interesting. That is really interesting. That tells me again that nobody wants to help Ms. Love in this. Not one in the district attorney's office wants to help Ms. Love. Or she's that narcissistic that she believes she could handle everything by herself.
And so I assume you have made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right.
Wow.
Yeah.
One more thing, we did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He sent it generally. It may
Oh. Oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that, that is the way that, that we would operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers, and I didn't.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so
if that's the case, we would ask, to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, it's evidence. But where proffers are okay, I'm okay with that.
okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So
Okay.
got through the
Come on, Lon, and see. The lawyers are talking. Why are we?
Sharp, Mr. Steele, we were in agreement that we handled those jail calls related to Mr. Copeland on Friday.
Okay, I'm sorry. I just thought there were like two things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection.
In relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay. So, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on, and there was other parts where, like, for example, one of them was Detective Gaither. He asked if we could, basically we either agreed or redacted or argued those 5 calls. And there's a
Okay, folks, I need to handle some business here. I will be in the background. I will listen in, but I need to take care of stuff because, as you might know, I'm flying to the United States tomorrow morning, my time. So in about 12 hours, I am taking a cab to the airport. And yeah. So I will switch over to Miss Sylvia's stream as soon as she gets there, because that hasn't started yet for some odd reason. Meanwhile, we have to listen in on the Lawn and Crim.
very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton. That
Okay.
encapsulates what all we discussed in our.
Okay. All right, so then moving on to our next issue. Yes. So, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on, and there was other parts where, like, for example, one of them was Detective Gaither. You asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton. That
Okay.
encapsulates what all we discussed in our.
Okay. All right, so then moving on to our next issue.
Your Honor,
Yes.
and good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins, and we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I
that's
think,
what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so right when we left court yesterday, when me and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it and we were in agreement?
Yes. That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele and Mr. Shard. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was in court.
Okay.
I will speak with them expeditiously
Okay.
to rectify that.
All right. Thank you. All right, so then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks, the stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's the applicable law, and that's where we're at.
All right. What about Mr. Matthews?
Yes, Your Honor. Good morning to the Summary Court. On behalf of Mr. Healy, we are in agreement that everything posted with recusal filing should be stricken from record.
Okay. And then Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Same position as Mr. Matthews, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the
Which I apologize for interrupting the court. I think there was one more party that
William, Stillwell, Kendricks, Huey, Ryan. Oh, guess, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right. I've asked you a couple of times to give me a proposed one.
Yeah, we have it.
Okay.
We have it. We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding.
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me in the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two stated. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in-camera if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. If, you know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a, yes, if it was coerced, then we need to redo all of it. Or, you know, find out, does he at this point kind of redo are you intending to take the stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay. All right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if, have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but, and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
throughout. So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate, that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of the this is or isn't perjury things are a little, I don't think, quite exactly accurate either.
Okay.
So I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Okay, so when, that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the, motion to compel that we had filed. Because it got to a point where he's trying to not testify. We would of course ask the court to compel him to testify. And the things that have happened. And he was, as I said, represented by counsel, as of course I already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week. And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face, and we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
Yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His father was fired, so no one has said anything to us
Okay.
about a lawyer on his part. So we are unaware of whether he has any
Okay.
representation. And I'd also point out just that since he is still under that immunity grant from the state, my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute of limitation that protects him from criminal liability. It's the immunity that would protect him.
Definitely.
And he was not exactly accurately advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are. Would that work for everybody?
Yeah.
Can I get an affirmative if that is in fact the case, not just like on the record, yes, if it's a yes.
On behalf of Mr. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean, no, that's fine. But can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of.
What's going on right now is that, well, yeah, I'm still preparing for my trip tomorrow morning. What's happening here is more or less the judge telling Miss Love, this time, don't lie to Woody. Don't lie to him. It's really bad when you lie to get a witness on the stand. That is my interpretation of what the judge is more or less saying. All right, see you later. I have to do more stuff.
Agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone reach out, just bring them in. We
Okay.
know where he is, so I can actually ask.
All right. I mean, yeah, if we can find him and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me. All right. So if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
right here.
All right, that sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking them about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if any defense counsel objects, I can send what Mr. Sharp sent us so the court knows what we're
walking through.
Yes, Your Honor,
That'd be great.
because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I don't. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay. Yeah, and maybe pick up your mic. And y'all, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet. So it's now on and I am holding it. Mr. Atkins, Ms. Love, Mr. Zachary's statement, his statement that I did not review yet, or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the 18 feds about the guns?
It's possible, and there were two statements.
You should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two, I think yesterday when I spoke, I was expecting one more from you. There are two, the 2015, the August 2015 one, and then I think it's the March 2017 one, and we have your redaction request for the I think the August 2017 one. So do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one, and then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
Transcripts of Zachary's potential, I guess it's statements over at Ms. Percival or?
Yes, Your Honor, and I was gonna also apply, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction chart that we discussed.
Okay. Waiting on that to come through and then we'll get started. All right, do you want to hand up the
Yes, Your Honor.
hard copy of the transcript? Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
The court can keep, but this teal colored one is gonna be what we're gonna discuss first.
Okay,
The red may come up later with the next.
I'll put the red to the side right now then.
That's perfect, Your Honor.
Thank you. All right. Ready with the first one? That's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a timestamp?
Your Honor, that is correct. There's a couple Mr. Short had that, for the most part, I could follow. So if there's
Okay.
a discrepancy, I may ask Mr. Short specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay. So, where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is. And then
It should be when it ends. So it'll be like 10, I'm pulling up my document.
okay. It is, I'm sorry. Go ahead with what?
So that first one would be. That first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right. So the very first one is I'm about to tell you something, and I've just said I wasn't there.
That's in the page 11, line 10.
Right. So it's obviously hearsay. So what's our exception?
You're on a part of it. When he's saying that he's at crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at crucial.
Right.
And he can't speak about being at crucial.
Mm-hmm.
I don't have any objection to him speaking about, or trying to speak about being at crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them, I haven't synced them up with my transcript in my
Okay.
recording. So, because I've read the transcript and listened to it so many times, I've gone through it with that knowledge.
Okay.
I haven't synced it up. So I don't have an objection to up through line 10. I
Okay.
don't have any objection to that. Page 11, line 10.
All right, so that's out by agreement. All right, so that one's out by agreement. You want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Is there something else anybody needs to take up before we take our morning break and let Ms. Love do that? All right. Anybody else? Nobody? Okay. All right. We're just going to take our little morning break early. So we'll be back at 10:30.
Hey folks, I was at the other end of the property when I heard, oh crap, morning break this early. Okay. They are moving on from the Woody debacle for now. They will return to it, perhaps by having Woody via Zoom or on site this afternoon or tomorrow. Now it is some federal investigation, evidentiary bullcrap that probably was resolved a decade ago, but it's an overt or underlying or overlying or sideways lying act. And yeah, not much. So they are having a break until 10:30. Okay, I will get you into some pause music, elevator music. Wait. All right. Thank you for being here, Bob. Thank you. Hey, it's 30 minutes. Would you like to see a video of mine instead? Let's see here. If I can get it up. That I did on another subject. Let me see here if I can find something interesting. Maybe this one. Hold on. Yeah. Many of you might not have heard about the Zachariah Anderson case. It was a case, a very infuriating case, where Mr. Anderson was wrongfully convicted, in my opinion. So, let me get this up for you. It's a 17-minute video, so we will be back in good time before. Okay. Enjoy. Imagine two strangers coming up to your house. Imagine them being quite threatening. Imagine them, one of them, going about his belt, almost as if there's something dangerous that he's trying to conceal. Imagine with these two people in front of you, asking you, are you that person? And you reply, maybe, in a manner that is suited for you. But imagine these are two people you've never seen before. They are very threatening. That you, no, it's not, no, I'm not that person. I am that person's brother. And then you call 911. Now, you don't have to imagine that, because that happened in another case I've been covering for over a year. The Zachariah Anderson case. I want you to listen to this 911 call and tell me what in that 911 call you see something or hear something that could be used against Zachariah Anderson in a court of law. Listen to it. Comment below what areas here you believe could be used against him. I'm going to play this. I'm going to go off screen. I want you to listen to it. Write in the comments below what in this 911 call you believe could be used against him in a court of law.
Mac 911, what's the location of your emergency?
This is executive transfer. The caller's at 6813 West Highland Road, 6813 West Highland.
Okay, and
Caller, can you go ahead and talk to the dispatcher?
Yeah, I've got two gentlemen standing in my driveway, posturing for physical harm, saying that there was some type of a confrontation between a friend of theirs. I'm not really sure. I didn't follow the story exactly, but I was on the phone with my dad. I walked inside the house and I called 911 right away. I don't know what they want or what they're waiting for, but... Okay,
can you describe the two people that are in your driveway?
Yep, one of them's got a shaved head. Both of them have facial hair. One of them's got a shaved head and one of them's got a hat on. White guy's about 6 feet tall.
Both white guys? Okay.
Yeah.
Facial hair on both?
Yeah.
All right. And you're not exactly sure why they're there?
No, they said that they were looking for somebody or something about a struggle. I'm not really sure.
Okay. And are you there by yourself, or did you say someone else was there with you?
Yeah, I have a girl over.
Okay. And your name?
My name is Zach.
Zach, what's your last name?
Anderson. I told them that I was their brother, though. That I was the guy's brother. That I was my brother.
Okay, so you gave him a false name to.
Right.
Okay, gotcha. And who's the girl that's with you?
Her name is Christine.
Christine. Okay. All right, and you guys are the only two in the house?
Yeah, please.
All right. Hold on. I'm going to get officers headed over there. You just stay on the line with me, okay?
Yes, please.
Okay, hold on. All right, Zach, I have officers on the way.
Yes, please.
Okay, are they still out there?
Well, I'm going to walk outside with you on the phone.
Why don't you just look out the window? I don't want to put you in any harm, okay?
They're parked in an awkward spot.
Okay, so they're in a vehicle?
They were out of a vehicle, but...
Okay, what kind of vehicle are they in?
Taking a picture of it right now.
Okay. Can you...
Yeah, I got him on the phone right now. He's asking who you are exactly. I'm trying to explain. Yeah, it's also weird for a couple of guys to drive up from Kenosha to find out or to check with him. What was your name again? You said Ralph and Mike? Ralph and Mike? He says he doesn't know you though. Of course he doesn't know you. You don't know him? What do you mean, what's going on? Him and my buddy's girlfriend.
I'm sorry, what was that?
He's saying something about his buddy's girlfriend right now. I'm not really sure I'm following the story, but.
Okay. And what kind of vehicle are they in again?
It's a maroon Kia or. Yeah. Like I said, he's over at his girl's house right now, but.
Maroon Kia, he said. He didn't say the SUV.
You know, I thought you came here looking for my brother. Now you don't give a fuck where he's at? Do you know where his buddy is at? No, he's saying he doesn't know what you're talking about, man. Did the detectives get a hold of you yet?
Was that to me?
Yeah.
Detectives get a hold of us yet? No.
I don't know. Yeah, I don't know either.
Huh.
No, like I said, man, he's not following that very well. AHD. Yeah, you too. AHD 8808 or something like that. It's a maroon.
AHD 8808. Okay.
Something like that. My eyes aren't that good, and I'm looking through the screen. But they're going to go.
Yeah. No,
on Highland right now.
They're leaving on Highland right now. Which way are they going?
They're going east on Highland right now.
Okay. Okay. Hold on. I'm still going to be able to hear you, but you're not going to hear me for just a moment, okay?
Yeah, I'm just running out to the driveway to see which way they turn.
Okay.
They're at Highland and Cedarburg Road right now, looking like they're going to continue east.
Okay, you said it looks like they're continuing east?
Yep, they're going east. Like I said, I don't know if they're looking to threaten me or whatever. They both got out of the car and started walking towards me or whatever, and I was on the phone, so I started describing them on the phone. Yeah, still east. I'm going to lose sight of them. They're going to go over the hill, east on Highland. The maroon, newer Kia.
Okay. Yep, you're right. That's exactly what it came back on.
Okay.
Okay, and my squad should be just about there, okay?
Right. They said that they were up from Kenosha.
Okay.
For something about their buddy's girlfriend. I'm not really sure, but I'm here with mine right now.
Okay.
So,
all right. All right. Are you still out in the yard or are you in the house?
no, I'm walking back.
You're walking back in the house. Okay.
Yeah.
Okay. Yeah, my officers are almost on scene with you there.
Are they going to stop the Kia and searching for weapons?
I have several on the way just because of how your call came in and everything. So I have several on the way. They're going to go look for the car, and I have a couple that are going to come talk to you as well.
Right, that sounds good. My guess is they're headed for Kenosha, back to the freeway or something like that if they're from Kenosha.
That's my guess too. If they went eastbound on Highland, yeah,
Right.
I have a car over that way that's going to look for them, and you gave a great description of the car and having the plate and everything.
Yeah. Yeah, this one. Okay.
Okay. All right, and you said you have no idea why they were there, huh?
No, they said something about their friend's girlfriend.
Okay.
Your friend and your friend's girlfriend, something along those lines. And I said, I don't know. I can't tell you.
And you've never seen them before, huh?
I've never seen those guys at all.
And did you say they were Ralph and Mike?
Ralph and Mike, that's what they call themselves, but it'd be nice to know their real names because they show up threatening me
Right.
about something. It'd be nice to know what their real names are and what they're trying to do, you know?
Yeah. Yeah, for them to show up on your doorstep.
I mean, I don't own a gun or anything for self-defense, so if they were coming here looking to do some harm or threaten me or whatever that was about, absolutely not.
Right.
And like I said, I diffused it just by saying I'm my brother.
Did they mention anything? You said that they were kind of posturing, but did they mention anything about them having any weapons or any intent to harm you? Did they actually verbally say that?
No, they didn't say anything. They just said that they were looking for my brother, and I thought one of them was going to pull a gun right away because he kind of, like, they both kind of kicked their legs out, you know, puffed up their chest a little bit, and then one reached for his belt or whatever, and I said that I wasn't me, and then he stopped.
Okay,
and,
so they did say that they were looking for you?
Yeah, they said that they were looking for me specifically, and I told them that I was my brother.
Okay, good. Good.
But I mean, they also said something, if the detectives had talked to me or something, I really didn't follow his story.
Yeah.
But I don't know if detectives were supposed to come and talk to me.
Do you have friends down in Kenosha, or were you down there recently for anything?
I have no friends in Kenosha. I don't know what they wanted from me. I don't know those guys. So, I don't really know what they were looking to accomplish or they were looking to do.
Okay.
You know, outside of maybe harm me, you know, why do you guys have to show up to ask me questions? And honestly, if they have my address, why wouldn't they have my phone number or whatever if you have a question for me? I mean, you know, they were here for some reason in particular. So.
Yeah. No, I agree.
Yeah.
Let's see. I'm just going to update my officers. Hold on just a moment, okay?
Right.
Okay.
13, she filed. Sadie filed custody for the kids, looking for sole custody, not shared custody and stuff. She filed on 5/13. I filed on 5/8. So she filed in kind of retaliation for me filing. And this is them serving me those papers. And yeah, so I've been notified that that's her interest in the case. You know, on the well-being of the kids, which makes sense. She goes to the bar multiple times every week and takes her kids at home. It's just an answer. Shit.
Hey, Zach, I apologize. My officers were all headed over looking for that car since you said it left the scene, so that's why they haven't showed up yet. But I want to keep you on the line if I can, just in case they show up again. Maybe they circle back around or something.
Yeah.
Did they know that you were calling us?
No, they thought that I was on the phone with my dad in the first place.
Okay.
I said, let me go call my brother real quick. And I walked in the house, and I came outside after I called 911, and I took a camera. I took a picture of the vehicle in my driveway. You know,
Perfect.
a picture of them. So,
yeah.
You know, so they can't deny that they were here. But like I said, if they're looking to perpetrate some type of harm or damage to my property or harm to me or anything along those lines, I'd like it well documented who they are.
No, I agree. I think you did exactly the right thing. That's what I would have done if someone showed up like that at my house too.
Yeah.
All right, I'm still here, but I'm just gonna put you on hold for a minute while I check with my officers and I'll see how long it's gonna be till they get there. Okay?
Yeah, I'm not worried. I'm not in any other hurry. I've got company here. Like, I'm a little, you know, I guess anxious or whatever.
Yeah. Oh, yeah. I can imagine. Yeah, I just in case they show up again, I want to keep you on the line. Okay?
Yeah. No.
All right. Okay. Hold on just a moment. Okay?
Right.
All right, Zach. I apologize for keeping you on hold so long.
No, it's okay.
I have officers on the way there right now. Because of this whole COVID thing, do you mind meeting them out at the end of the driveway so they don't have to come in the house?
No, that's fine. I'll even put a mask on if it reassures them a little bit. Because I have one of those.
If you want to, you can. It's
I'll bring it with.
Okay. Yeah. No, that's perfect. And then, just so they know that it's you at the end of the driveway and not one of the other guys. What kind of clothes are you wearing?
I'm in a black hoodie with a white t-shirt on and jeans.
Black hoodie, all right. All right, are you on a cell phone that you can stay on the line with me while you head out there?
I can, yes. That would be
Okay,
fine.
good. That way, if anything were to happen on their way there, you know,
Of course. Yeah, of course.
I can let you know, that kind of thing.
Right, no, absolutely, absolutely.
Okay.
Just want the police to do their checking. Those boys are
No,
up to
I
some kind of
agree.
trouble, you know?
Yeah, no, perfect. Okay, hold on just a minute while I let them know that you're coming out, okay?
Yep, thank you.
Okay.
They want me to wait at the end of the driveway. You want to wait with me? Okay.
Is she going to go out with you?
Yeah, she's walking out with me.
Okay, I'll let them know that you're going to have her with you so they don't, you know,
Yeah.
wonder what's going on. Okay, hold on. All right, just let them know that there's going to be 2 people out there.
Yeah, thank you.
Mm-hmm. Is there anybody, oh, never mind, you said that Christine was the only one there, right?
Yeah, just
Awesome. Excellent.
neighbor.
And what's Christina's last name?
Remsburg. I want to know who you are. Arrest her. Have them arrest her. It's the traditional spelling. I'm not
The
sure.
traditional spelling, right?
Burg, like a hamburger. What a
Hamburger. So B-U-R-G?
Yeah, just B-U-R-G.
Okay.
Hey, people came here to kill me today. Why are you pushing me? Whoa. Chalk that up to the weirdest shit that's happened to me in a year.
Yeah, that's you know, not something that happens to everybody every day.
I mean, you know, I thought I'd at least throw them off because they were coming at me with the both of them got out of the car and started coming at me.
Yeah.
And asking me who, well, that's my brother. And then they, Mike got the wrong guy or, you know, whatever. And so that stopped them for a second. But if they showed up with, you know, a gun or something to,
yeah.
something funny, you know. Can you say what the fuck when you call 911? Because that's how I feel.
Yes, you can say that. We're used to that.
Right.
Definitely.
Right,
And my officer should be pulling up.
Yeah.
You see him? Are you out there?
Two squad trucks here now, so I got
Perfect. Yep.
Yeah, thank you.
Okay.
I got.
All right, I'll let you go then, Zach.
Out on the road. Sure. Is that okay? Yeah, we'll start right over here. Wherever you're comfortable. Suspicious people over here. Yeah. Do I let you go now?
Yep. I'll let you go then. You're out with them. Thank you.
Thank you. Yep. Thank you.
Bye.
Bye.
And right after this, Zachariah Anderson was arrested. And after one mistrial, they retried him and found him guilty, the jury, because of one speck of substance they claimed was a match to a person named Rosalio Gutierrez Jr. The cops showed up after this call and arrested him for another crime. The murder, concealing of body, and stalking, 2 counts of stalking. And if you listened in, you heard about Zachariah saying this about a child custody case. And the prosecution turned this call into a conscious of guilt thing, claiming since he told these 2 strangers that he was somebody else than him, that proved that Zachariah Anderson was somehow a dishonest person. I have a playlist of the Zachariah Anderson case. I do fundraisers for his appeal from time to time. If you have the time, then please check that playlist out. We are currently waiting for the court to come back. They aren't back yet, and I want to play something else for you. And this is when I get committed to a case, and Zachariah Anderson played this or recorded this to me.
Okay, let me see.
But let me at least say, because I know Nicholas, there might be some lag to this. I see you're kind of skipping around, but Nicholas in particular has been part of the group for a long time. Early in, recognized that it was bogus early in, you know, and I appreciate all the help. And he's still here, and it's super cool, and I really appreciate that kind of stuff. And I know anybody that actually bothers to look is going to know how bogus this is, and it's really hard to get people to take notice in the first place. But I know he's been out there, and I know he's been doing things, and I know he's been connected, and I want to go visit the guy, you know, and be on the show and go visit the guy and all sorts of stuff. I mean, I just think it's super cool. All the help, thank you. Super cool, and I appreciate it. And everybody else too, but yeah, he's in particular, I don't know, he jumps smart. When people talk about like other people's shows, I don't really know other people's shows, but I know his, because his was like one of the first ones that got mentioned. And I'm like, really? Somebody's actually doing something about the case? I'm like, oh, that's cool. So anyway, I don't know. Don't know the guy, but really appreciate it.
Yeah. So when I say I'm going to cover a case, I'm going to cover the case. And for me, I mean, this was in Kenosha, Wisconsin. And one of the most moronic thing that the state claimed was that Zachariah Anderson, I mean, 6 foot, 210 with a chronic back injury, somehow took Rosalio Guterres Jr., 6 foot 1, 270 pounds, in a rolled up carpet and carried him out from the apartment without leaving drag marks or droplets. Nothing. Pushed him into the back of his work van, which is one of these family vans, you know, the 7-seaters, in a 3 foot by 4 foot square area. And the only thing was one pin, I mean, you know, the top of a pin speck of brownish substance that couldn't be tested for both blood and DNA. And this Rosalio was his ex-boyfriend. Rosalio Guterres had at least 3 other women than Sadie, at least that we know of. He was connected to less than honest people, let's just say that, who he from time to time owed money. But they went after Zach. And there's no record of Zach being in the Rosalio's apartment. There's no fingerprints of him. There's no DNA of him. There's no cameras showing that he drove there or back. There's no eyewitnesses who says he was there. None. Nothing. All is one pinprick sized brownish substance the prosecution alleged was a match to Rosalio Guterres. They brought in a prison snitch named Munch, who claimed on the stand that Zachariah Anderson made a sleep-talking confession to him. I'm not joking. I'm not joking. I wish I was joking. I'm not joking. The prosecution claimed that Munch They could do nothing about his sentence. Nothing. That is why he was honest on the stand. 3 months after Zach was sentenced, Munch was released from prison. He was convicted of carrying with intent over 20 kilos of different drugs, weapons, other charges pending.
Agreement on
He was
anything?
facing life
Judge, I
in prison,
have
and
just
now
been
we are
reviewing
back
Mr.
to the
Sharp's
trial.
proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but we've already given the court the first one.
Okay, I'm going to back a bit there. Now I have to. Oh, that was this was no, not that one. That one. Okay, I need to fix more stuff before I travel tomorrow. I will keep listening in. You know that, but I need to take care of stuff. Okay.
Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but we've already given the court the first one. Does the court have a copy of his redaction? I can get the court.
Yeah, the proposed redaction, yes.
Yes. Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All right.
As well as number 19, which is on page 73 of the transcript.
All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Could you just give me the number of the second one you had no objection to?
17.
So 17 and 19, I
Okay.
also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to is?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right, so we had gone through 23.
24, 25, 26, I don't agree with. going to 27, it is 9211. Keep out. All the way through 9422. (9211) through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or
All right.
I can.
Let's do that right now, and
All
then over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those. Okay?
Did the state agree to 27 or no?
It's,
No, we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yeah, so I mean, it's, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up a house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up. And this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shot up. It's why the house got shut up, which the objection's speculation.
So my argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D-Fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14 line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the, granted as to speculation.
Okay.
And if you establish it,
Okay,
then that'll be a different story.
that'll work. 14. Okay, so the next one being page 25. No. So 25, page 25, line 9 through 2512 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay.
And what they were doing. It's an admission.
All right.
It's an admission against his.
All right, so what's our objection there, Mr. Short?
My objection is drug use, and the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you.
Right. What's the motive? The motive's just They were high.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number. So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25.
17 through 20.
Yes, I'm sorry. So 17 through 20.
Right.
He's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes, so.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in this proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says, Mr. Stillwell was there, and this is what Mr. Stillwell said, or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked, what was y'all's intention? And that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it. that
All
they
right,
are
so
having
where's
a
that?
So up. On line 4, he says, because he said we don't shoot houses, leave that to them. So on line 2, investigator Dennis asks, why does Muntung, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's
Line 9.
talking about what Muntung said. Muntung's not even here. My client is not Muntung. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car, according to Mr. Zachary. But what Ms. Love talked about is Moontunk telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It
Okay.
is. Okay, so assuming you need to use it as a prior inconsistent statement.
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend, Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right, 28, line 17.
The
No.
font is a little small. I'm just having,
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this incident. The
So
shooting of
this
the houses.
one, we have given the list of 30 witnesses, and one of the first 30 witnesses, one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister getting
Okay.
shot at. So there hasn't been.
Did somebody get shot at this house?
Yes.
And that evidence will come in through this
The-
other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot?
Yes.
Okay, so then that is all right. All right, number 6.
29, we just hit.
And I guess let's make this 3-page proffer of proposed edits a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it
just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just
How would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it
don't-
out. Strike it. Granted.
Yeah, okay. Out.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed redactions. Okay.
So
All right.
number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Monktunk, Demikian is in the back with you and Shannon is in the front, and then and then Mr. Zachary says they were in another car, yeah, and they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindaria Zachary about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kel, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count one in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but.
No, line 17, where he says they tried to say that we did it on on page 33.
Oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish
the existence of the enterprise, the gang, and the fact that there's an opposition and a they and a we.
All right, Mr.
So,
Sharp.
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe, I don't know.
with
I
this-
know, they're all annoying, they get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purposes of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. That he's telling the story, and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides, a January 27 of 2015 incident, 150262801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
But
an
that's,
associate of YSL and a member of YSL aren't the same thing.
they aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person,
Go ahead.
she does.
so
All right, let me,
so if gang is the gang that
so
they're
is that the they here? This is the
associates
part of the gang
yes.
that there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusation.
Hey, folks. Hold on. There. Why isn't Melnick still Woody's lawyer? Mr. Melnick asserted to the court, I remember, that if Woody takes the stand, Melnick cannot represent him. Now, usually that means that if you as a lawyer have knowledge that your client is going on the stand to lie, you have to recuse yourself because you cannot condone that conduct. That is my interpretation of why Mr. Melnick isn't still Woody's lawyer.
By an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? And if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant and it confuses the issues.
And if the court goes on further down,
Mm-hmm.
and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right. So,
He's literally saying, no, that didn't happen.
right. But she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, whatever it is.
So right, I understand fully. Like,
Then
in
he
other words,
says something
don't try to
different. You're like,
don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Number 8 being page 36, lines 1 through 30.
I'm sorry, I hadn't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And Your Honor,
And
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8, so,
Okay.
all right, so agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel, It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay,
talk about another car being shot
all
up.
right. Is
Has nothing to
that
do-
relevant?
So, Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right, so that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because
Let's
this
not wait
happened,
until the last minute to do it. Okay.
it would only be by virtue of something happening on the stand.
Okay, I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay,
K-
so
and
that's
boy called
lines
KL.
3 and 4, is that Tay? Yeah.
And 16, where he's talking about the other boy called KL. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay, well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. Line 8.
Okay.
Through 39, 11.
Well, really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about Tay, people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in about Tay one way or another.
Right.
But I'm just trying to limit confusion that the
Right.
jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right, she may
Oh.
not, she may agree.
I have no objection to 8 through with the clarification that he made because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay,
of
so,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 to
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all?
19.
One, okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then
Yes.
they start talking about Tay shot Kel.
and
I don't represent Tay. Tay's not associated. So, but it's just I just think it would be confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who is dead and not on trial here, right?
Well, that's true, unfortunately.
Okay, so is it relevant? I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
Yes, it goes over into page 40. There's a video that we're gonna have with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is If Gang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mm-hmm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're going to introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kell on social media over a common girlfriend and Tay shooting Kell. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, I'll take it out.
We'll take out. So it's going to be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what now?
To number 9 on my list is the continued discussion about the beef between Kell and Trevante, and they start out with Trevante shooting Kell, and then they talk about how Kell allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary.
We don't.
Saying his understanding was that Kell shot up his girlfriend Trevia's house.
All right. Hang on. Ms.
So-
Love.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Antrevia's house, that part is correct, because Antrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her.
Mm-hmm.
So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Antrevia Smith's house got shot up.
Mm-hmm.
It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevia's house, that's one thing, and it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevia Smith's house. Mr. Zachary was not shooting at Trevia Smith's house or being shot at Miss Smith's house, Trevia Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shelkel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right, let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right. So.
So the next one is number 10 is 42. Line 17 through 44, line 6. So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shelkel shot up the gambling house on McDonald Boulevard. Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our objection to that.
Okay.
All right. All right.
So I'm gonna take that out.
All right, number 11.
45.
That should,
15.
number 11 should be 46,
Okay.
line 15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clanethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have.
All right, that she agrees.
Coming out. Mm-mm.
Okay.
What's your name?
So that's.
That's 45, 15 through 46,
Yeah.
16. I agree. Okay, let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now, so why don't we pause what we're doing with this and have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good.
we
with that.
could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's-
Okay.
Okay. Wood is in the house, apparently.
All right, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters, but I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know when to testify.
Okay, the first, well, right, want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then if you don't know
I'm
whether.
saying I was talking to Melnick, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
That was against Miss Bumpus.
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was stand-in and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was,
There was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe we,
There was, Miss Bumpus actually said yesterday, I believe during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't testify,
over.
what? So if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes.
not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
All right. Here's my take on this. I think Wood is going to plead the 5th and be put in jail because now, unless information is gathered by the state that, oh, you can hold him indefinitely, which I don't believe they can, and the judge wants this done before the end of the year, I think Wood is pleading the 5th. And if he has to spend the next 4 or 5 months in jail for it, I don't think he minds. That is my take on it. Will it happen? I have no clue. I really, really don't have a clue. But yeah, as Craig says here, Woody sounded very happy when they heard the end of their trial. Yeah. Oh, this will be interesting. And I have so much to do. I thought they were planning on getting Woody there tomorrow, because then I definitely have a valid excuse for not covering it, because I'm on an aircraft over the Atlantic Ocean. So I really can't stream it live. Unless I can I have 2 people who can start and stop streams for me. If they can do it, then yeah, sure. But I can't. Peony says, how can we put him in jail for pleading the 5th? Because the state has offered him immunity. And that piece of paper, which is, in my opinion, not that comforting, removes completely Woody's 5th Amendment rights. So, yeah. So that is why he will be in civil contempt until he testifies or until the end of the trial. Wow. Oh, this week is so epic. Auntie M, if I would STFU. I don't believe the state can detain him for an indefinite period of time. I don't believe so either. I believe there's good case law to say, no, it is on the end of this trial. If they want to use him in the other people's trials, the severed cases, then they have to do that again. The same, subpoena him, offer him immunity, put him on the stand. But now they know he will plead the 5th. And I do believe the prosecution has a candor to the court to not put a person up on the stand who will plead the 5th, if they know he will do it. So, yeah. Yes, and Cat, not Williams, will be streaming. So you will find somewhere to watch this. Regardless, I'm quite sure of it. Okay, let's see what the rest of up until lunch does. After lunch, I will send you off to Cat, not Williams. Or do you want me to keep streaming the entire thing? Put a 1 if you want me to keep streaming, even though I can't be here that much. Put a 1 in the chat. Or give Woody a better deal. That sure. I don't know how they can do that. Okay, I see 1s. Okay, let's keep going. But during lunch, I can stream Snipe the Cat during lunch. All right, let's continue.
So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority
Yes, Your Honor.
lets you believe that. Okay.
Your
All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday.
Mhm.
She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said.
Here's the thing. They are starting all over with Woody's testimony, which means it never happened in the eyes of the court.
Was if you plead the 5th, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good. All right, so we were on number 12.
Number 12 being page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay. So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, we would argue it's Mr. Zachary's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Shart's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
being
ability
a
to.
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
So
let me ask Mr. Shart, is the basis for you saying you don't think he was there that no on line 23 when Is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no, no,
Okay.
it's not based on that.
Okay. You have no
actually
reason
do
to
not
believe.
know.
Okay,
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
okay. Do we
And
know
I-
whether
and
he
this
was
is-
there?
Page 48, line 5, start at line.
Oh, so we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And
I
then
withdraw.
somewhere else, he says, would he, okay, all right, well then, you'll withdraw that objection?
If he was there, then yes.
Okay, so that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donald Thomas. Zachary repeats the question. Ultimately, Zachary says, should they say Woody and them? I don't know for a fact. So I would agree and argue that he don't know.
Okay,
So it's
He's
not,
telling them,
okay, so 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relates to law enforcement about statements made to him by 2 people in the courtroom now. And 2 people admitting having killed Diamond Thomas.
Okay,
This statement right here is after 2 years later. So, when he says, they say Woody and them, I don't know for a fact.
mm-hmm,
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
okay,
so, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually, in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt, and Mr. Stillwell told him that they killed Mr. Thomas.
okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay,
So if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
mhm,
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
it's 18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know,
later on he says, my client directly said this.
all right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see who
He
you,
is
I see what
holding-
you mean.
yeah.
If he's already said, or he will later
He's
say,
going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him
okay,
at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
all right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think
right?
ask
So,
who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be, this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511. Is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22?
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that.
All of that, we would object to it being redacted out. All of this is Mr. Copeland talking about.
Okay, so, all right.
Not Mr. Copeland, Mr. Zachary, my apologies. So I don't know how.
Okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, no, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is if I flip back far enough?
In this particular interview, no, not as it relates to
Oh, good
this
Lord.
statement right here. Because it's one of those.
It's all over the place.
No, it's as it relates to the way that Dennis is talking to Zachary.
Yeah.
He means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video of this part because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's an MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds.
I believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move to the next one or is it?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me that video. So yeah, let's, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right.
I have 3 digits. I know it's meant to be a typo probably. Is it just 5722 to 5723? Because it has 223.
I think so. Your objection, Mr. Shart, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is
I'm going to withdraw that one as well.
All right. Then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but
Right.
I can understand that. You wanna agree to that, Ms. Love?
Judge, if the court will give, my counsel is in here whispering in my ear, the court will give me 1 second.
To get there and consider it? Yes, I will give you a second to do that.
I'm here in the court.
We'll see. I'll give you about 10 more seconds to make your decision, then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection to that. That's all of number 15, and number 16 starts at page 66, line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12, starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then Investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count 1 and the gang count in this case.
That's not my issue.
Count 1.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontook or that's Moontook's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's
Okay.
mom's house. And there's a couple reasons. A, it's not been put in
Okay,
evidence yet.
well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So
by
really 16
redacting a smaller part of it.
I should have said 16 to 17 if I was
Okay.
to be more precise.
Okay, so any issue with just with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quindarius Zachary. No objection at all.
Okay. So that's 66, 17 through 18, out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was.
Yeah.
Was the court asking?
I don't, Mr. Sharp, did that have some issue?
right, 60, they're going back to Lucci mom's house and then they're saying The gun you got caught with has something on it until you didn't know until you went to court yesterday. So I think that should come out 6819.
Okay, so then maybe we just aren't lined up with line numbers.
Yeah, that's
So 6819 through 21, right?
I would say.
25,
Because then they go to Lucci Mom again.
well, 24 maybe?
Right, okay.
Okay, right?
Yes.
So 19 through 24, out.
And then
All right, hang on, let's make sure that we've got agreement on that.
So when 19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shootings on it. It's one of the guns used in one of the shootings. So even though, as it relates to the previous portion that I agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's no Tuke's gun. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says it has shootings on it. Yeah, it has some shootings on it.
he says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm going to exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised. But I mean, if that's what you wanted in for, make that argument. But I didn't hear that argument. So that would be lines. So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am going to exclude that. All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, halfway through 2.
Okay.
Through 5, really.
Was that page 69, line 2?
Yes.
Yeah, lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so Judge, when Detective Dennis asks who shot up Lucci's mama's house on page 69 at line 25, and Mr. Zachary gives them an answer. I would argue that all of this is information that I should be able to ask him about
And if he doesn't, I mean, if he testifies inconsistently, it should be able to come in. I'm not looking at his reason for asking it to come out, so I look at it.
Yeah, what's your,
There's no indication.
how he knows?
To the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says, I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on, but I don't believe he's going to say that. And he needs firsthand knowledge or another exception or another hearsay exception. And I don't see it in the state just kind of saying, oh, well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case. And I think that the investigators are not trying to criticize them, but they're just trying to gather information, not in preparation of trying the case, but just trying to get some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we would ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Thug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he said, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be a to say who did it and then didn't you tell them. I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you asked him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge. you know?
Yes, yes.
So I don't know if
Can we
you,
swing back around to that one?
we'll swing back around to that one. Okay. Let's see. I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation regardless of its as to his testimony on the stand or as to this, you know, but yeah, it kind of let us know what that's going to be so that I can make a determination of whether it comes in, you know, potentially.
Which number are we on?
Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay. We're going to break then. All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. You know, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
Damn, did I miss that? Are they on lunch? Are they on lunch? Let's see here. $1:30? Okay. Let's check in on. Ooh, let's see here. What like this? Nope. There.
It's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
Paging Mr. Melnick. Aaron had said for $4.99, thanks for the super chat. Get on the phone with TLA. Send him down to save Woody. Can you imagine if you see someone like TLA or who are some other Atlanta attorneys just going up in there and they're going to represent Woody? I mean, that's not TLA's specialization, but somebody get in there and represent him today. And maybe Melnick's in a hearing, like busy doing something right now, but he'll answer his phone. Maybe he's in the courtroom somewhere else. I guess they'd probably know that, though. Amber Down, thanks so much, says, or Amber Dawn says, Woody the Fifth spread the hashtag, y'all. And then did you see Love's face when she said Woody's here? So guys, I think we should rewatch that during lunch. The like 5 to 6 minutes that Woody came into the courtroom. And we can watch again with a second pair of eyes and see what goes on. So let's do that after. I want to shout this out. Thank you so much to Mahadi De Jesus. Sends a 50. That's so nice of you. This was a great move by Woody. Guys, put a 1 in the chat if you think Woody coming in and Judge Whitaker just doing that quick inquiry. If you think that that was a good move for the defense in this case. Put a 2 if you think it's going to go well for the state. But Mahadi points out that this is a reset for Woody and the immunity. And we get Judge Whitaker on the record to, I'm sure, the state's dismay, to say, look, there was some false information that y'all gave him in this June 10th ex parte as far as how this immunity coverage works and his protection. There was some false information given. That's not a great thing for a judge to tell you. It's really not a great thing. So thank you so much, Mahadi. We are going to go back and look at that. I had bookmarked this earlier, and I think this is a great thing to mention. So Ms. Nikki, thanks for the $9.99, had said, is it proper for judges to consult other judges while presiding over a case, especially consulting on how to decide certain motions? So yes, judges can confer with each other. They often do for scheduling issues if they're in the same court, but they can also go to each other for advice on, you know, is there authority here? What would you say? What's your insight? But at the end of the day, the judge, the seating judge that's presiding over whatever case they're talking about, is still the one that's supposed to make the decision. They're not supposed to abscond their role to a different judge. So they can get advice, but they're not just supposed to go to someone else to make the decision for them, if that makes sense. So great question. Shout out to Mason Martin for the super chat. No message, nothing, just a super chat. I appreciate you. And then Chance, good to see you, Chance, says, Kat, you're the bee's knees. Keep up the good work. I do believe it's far past time for a mistrial. Steele was right yesterday when he said there seems to be no consequences for the state's conduct. And again, that inaction essentially ratifies the misconduct. By doing nothing at all, you're essentially saying it's okay. You're making it okay. And I see you guys have a ton of ones in the chat. Ton of ones. So yeah, you guys are right on board thinking like, Woody, this is better for the defense. And thank you so much from Nick Starro. So you're still live and stream sniping. So everyone wave to Nick Starro's chat. What's everyone having for lunch? We're going to get to that clip, but I do want to jump back to, we've talked about it on this stream. I've seen it talked about kind of a lot on a bunch of streams. Everybody looked at it when it was first published.
I will be in the background.
But back in June, Woody had made this post on Instagram in all caps. He is an innocent man in real life. The demons that has been on me at certain times in my life had full control. It took years to break free of those demons, and now my conscience is eating me up. I'm not allowed to, and it's like the talk emoji, but I pray to God that they pray and trust in him, that he reveals everything that's going on. Every single person that steps in that building. What building does he mean? Every single person that steps in that building have been violated, and they show us time after time that they run everything. I lost family members, my kids, and at the point of losing my sanity. Now there's 2 smaller blocks of text that says, this is not freedom. This is a country that bullies others to comply. This is a country that takes what they want. And this is a country that will not stop until they get what they want. And the other paragraph says, now come lock me back up. I ain't scared. So Thugger Daily had just done a flashback to this post. A lot of you guys will remember it. If you haven't been paying attention, if you're stepping into this kind of new, what do you think about this post from the end of June? And what it might suggest about how Woody will testify if he gets back on the stand. Boosh McFadden says the building is the building of love around his heart. Well, yeah, you guys, the courthouse. Now let's go watch the clip. We're going to rewind. Let's go find him back on the stand. We're going to rewind to right when they say that he's here. Let me put a banner so people aren't confused.
Yeah. Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters. But I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I never wanted to testify.
Okay, the first, well, right, want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no.
She was looking at him, but looked down as soon as he looked.
Melnick, but
Melnick?
yes,
Okay. Didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I'll listen to her answer.
I don't believe it occurred.
Okay.
I believe that Miss Bumpus,
I know she was stand-in. And
she was stand-in, and I believe something was said on the record to the effect that Miss Bumpus was relieved. But
yeah, I know she was.
There was nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was, Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
well, choose not to testify.
Right. Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so
And that part bothered me because they apparently did their homework between June 7th and June 10th to figure something out. They came up with a solution. We didn't explicitly hear what that solution was, that thing that lawyer love loves so much about this great law that we have. But we know on June 10th, they come in and say, well, we could hold you even longer than this trial. We don't hear the authority mentioned during that ex parte. There's no reason to mention the authority out loud if the judge is already on the same page for whatever reason. But if you had done that research to find that way, why aren't you aware of the authority right now, present day, when you know you're still struggling to call this witness? Why might you not be aware of the authority that you relied on to say this thing you said on June 10th? If you made that up, and you can't find that now, and you also gave false information, how will Judge Whitaker not see that as coercive? Especially, and the defense attorneys have made this argument, this is an experienced attorney. Hilton is also an experienced attorney. The judge also should have known. If there is no authority because they made it up, How do you not say that they knowingly tried to coerce and pressure Copeland to testify? And even better, we get this one question from Woody. What's Woody's one concern here? What did we just hear him say?
I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
There you go. So they've got to figure out that stuff with Melnick. I'm going to get it back to real time. Because, you know, what if they just pop up? They're like back in the courtroom, the sound comes back on, and they have an issue they need to handle right away. Nothing would surprise me. Catch that up, get real time. And they're not going to have sound going, but... So back to Army Nurse here, because Army Nurse had said, Kat, if they are starting Copeland's case again and removing his last performance, can the judge remove his immunity signed by the previous judge? Now, what's interesting here? Judge Whitaker is saying, like, look, we want to at least go through the immunity order that you have and make sure it's properly explained to you. We don't explain it with false information. We're not giving you bad advice. This is why we'd also like you to have an attorney here. Although, honestly, I think Judge Whitaker explaining how use immunity works is probably a mile ahead of what the state was doing. Although he should have counsel present if he wishes to have counsel. But if they were to remove the immunity signed by the previous judge, they'd have to go through that whole ordeal again. Will we not end up right back here? Because what would prompt that? He gets back on the stand. He doesn't want to testify. The state wants an immunity order, so they'd have to ask this judge to sign off on one. They want an immunity order for this same witness. Then they need to explain why. And do you think Judge Whitaker, if she doesn't buy into this authority that's apparently out there in the universe somewhere, that we can hold you for as long as it takes us to try all of these co-defendants? Do you think Whitaker is going to advise Copeland, we can hold you longer than these 30 or so weeks that I want to keep this trial going for? Because in my memory, Copeland seemed all right with possibly doing over a year, close to 2 years, to sit this trial out. He didn't want to stay for the other trials, but he seemed to be willing to do a year or 2 for this trial. 30 weeks is a much smaller ask than 1 to 2 years. So I don't know if the judge is going to necessarily remove his immunity, but Copeland's already presented the idea, the possibility that he's just going to refuse to testify again. And then we have the separate remaining question where he thinks Melnick's possibly representing him still. Melnick may or may not wish to withdraw depending on what Copeland wishes to do. Melnick doesn't seem to believe I can represent Copeland to the best of my ability or properly if he, depending on what he does, because I don't know when I would want to object. I don't know when I would need to step in because he might not be protected from prosecution. So still a lot of moving parts that honestly the judge hasn't gotten answers on. And the only win for the state, I think the only win for the state, is if things remain as they were. And there's absolutely no way that things are going to remain as they were. The state is going to lose something that they're hoping for. I think they're aware of it because just by the body language. I mean, we opened today with Love being concerned about the subpoena for Kenneth Copeland. Copeland walks into court. Like, come on. Yeah, you guys are calling it. And we don't think he's going to testify. Don't think he's going to testify. And yeah, Cheryl. So Cheryl says Judge Whitaker would be able to explain the immunity to Woody far better than any of the attorneys present. And I don't think it would necessarily be right for the defense attorneys to try to explain it, right? He should have his own counsel. But the state, even though they're experienced, they shouldn't be using a misrepresentation of the way things work to tell someone why they should testify. And I really don't think that the judge liked any of that. So Nancy New, thanks for the super chat, says, Woody didn't understand Hilton most of the time. How on earth is he going to understand Love? And I don't know. I don't know if they're going to have Love question him because he apparently won't talk to Love. Can you imagine if they have Love question him? Like, he was already dismissive and did the step back to Hilton. And I don't think he had as much of a gripe at that moment in time as he has overall and currently with Love. Maybe he doesn't like either of them now. And what do you think if a man leads the questioning? You know, the gender can make a difference. Let's just call a spade a spade. Woody could be more aggressive, more hostile towards Atkins because it's another guy. There's no issue of I don't want to hurt her feelings. You know, that could play a role too. I think it would be most interesting to see Atkins do the questioning because I really don't think it would go over well. Love, I think she'll get one-word answers and that's it. So I don't know. Do you guys think Love's going to be the one to lead the questioning? So thank you for your super chat, Nancy. And thank you, K1. Just 199 says, great job. I try. Thank you guys for the patience with the sound issue. StreamYard had gave me a message that I lost audio from the shared screen. And I guess you guys, the ones that were watching it in real time, now I know that I have to take down the screen share and then redo it and it fixes itself. So now I know how to fix that next time if it happens again. So sorry about that. And then Garrett S. says, state and judge gave Woody incorrect info and that coercion, 100. So, and that's the thing. They said they did their homework and came up with a solution. But then they still gave incorrect information. Experienced attorneys. They should know better. I feel like even if it doesn't cross the line of malice, the ignorance is inexcusable. And especially to have that conversation with an attorney that was standing in and hadn't seen a copy of the immunity order. I noticed that too. So thanks, Big Tip, for the super chat. How was Woody able to have his phone on the stand? My best answer is it's Woody. It's Kenneth Copeland. And I think the judge didn't mind because, you know, maybe he showed up impromptu and may have been looking at his phone to see if he could hang around later that day. And the judge would rather him try to make sure he can be available later in the day to get this moving. So she didn't want to pick her battle on that. But let's listen. If he comes back today or if he comes back tomorrow, whatever the case is, let's see if she says anything about devices when he comes back into the room. And it's possible maybe a deputy could say something to him too. And then Pierre. So Pierre says, judges fixing state problems and not disciplining their actions. It's not Brady because you have it now. She didn't seem to agree with that yesterday. There was a small conversation back and forth yesterday where Love tried to say that, make that argument. And you could tell she was going to make that argument because of her lines of questions, the way she was asking certain questions to Kayla. But you ended up telling defense attorneys eventually, right? At least one of them. And Love tried to equate what Brady says. Brady wants you to have equal access to Brady material. The defense should have equal access to whatever the state has that fits the criteria of being Brady material. And Love was trying to argue for reasonable access. You know, If you make a reasonable effort, you could obtain the same Brady material that we have access to. In other words, removing the duty to disclose. But that's not what Brady says. With Brady, it's a duty to disclose. So Love tried it, and I don't think that argument landed on Judge Whitaker. She reminded us all that Brady is something that we should all in this courtroom take very seriously. So while I'm waiting to see what she actually does, at least verbally, she did give some pushback against the way Love tried to characterize or take creative licensing with what Brady means. But again, we don't know her giving pushback in the courtroom. We have to see what actually comes to play when all is said and done. So I hear you. I'm having a little bit more patience, and I don't mind people questioning the judge at all. I've had moments where I'm like, all right, what you're saying would be reasonable if there wasn't all of this context behind it. Because if you're starting from a starting line and you don't know everything behind it, I get why you might think that. But this is a serious case. There's serious charges against people, and all the stuff that happened before here is really relevant. And I think there's been too many occasions where that's been dismissed. All the stuff behind us, we're just looking forward. I don't think it's appropriate or fair to detach from 100 previous days of trial. So I'm not opposed to the criticism at all, but I do think here with Brady, I'm personally interested to see what she ends up deciding or saying. Because I don't know, she seems to really not like that the state played that game. But who knows? And then Kushizuku. Okay, so I know a lot of people here are from the United States and other people are from other countries. If you're from the United States, speak of it as your state. But if you're from another country, let us know what goes on near you. How transparent are your courts? Are there, statewide? In Florida, we're pretty transparent with cameras in the courtroom. A lot of counties have decent public records access. And yeah, we can look back at the transcript. I saw this. Let me pin this. But a lot of other states, there aren't cameras. Cameras aren't required in the courtroom, and judges can just say, nope, not doing this. And then it's really pesky to try to obtain some records. So I am a fan of transparency in the courtrooms. I think that trials should be documented to the best of our abilities. It's not that expensive or cumbersome to set up technology in the courtroom. Get Wi-Fi in the courtroom, get a basic camera, basic audio. I know they're struggling with the mics, but whatever. If we listen hard enough, we can technically hear what's going on, in addition to the transcriptions. Plus, with this case, because it's high profile, Fulton County made the documents a bit more accessible than a regular case. So that's helpful too. But this transparency, I mean, we're getting more transparency in this case than we would in other cases. And we're still like, well, what actually happened? Wait, we don't remember that, but we're able to go and look back. And that's not available for other cases. So huge problem. It drives me nuts, the idea that courts can't be bothered to put a camera in the courtroom. Federal cases aren't really that transparent. That sucks. And maybe federal trials have a bit more seriousness behind them sometimes. So maybe those should be the ones that we get more transparency with, but I agree with you wholeheartedly. Stay Tipsy says, how is that not prosecutorial misconduct by lying to get testimony? Then the judge is trying to fix it. That's crazy. The judge admitted it. So I agree. And I really think this is why they didn't want to disclose the June 7th meeting when everybody had found out about the June 10th meeting. And what was also interesting yesterday, that we know that the judge had unsealed records and resealed them, but she said she made a copy of everything. She said she's got folders and folders in her office, her chambers. She's got all these sealed documents. So I wonder if she can go look and see if there's other sealed proceedings, maybe around June 6th and June 7th. And can you imagine if she were to find out that something else still wasn't disclosed? after all this, after she spent a whole day of court yesterday trying to get answers. And then she's to find out that maybe there's another meeting that the state didn't disclose. I think coercion, though, I don't know if she'll think it was intentional or say it was intentional. I think she's going to continue to say that he was improperly advised. And that sounds like misconduct to me. But do you think she'll make a finding that if she finds coercion, she'll say that the prosecutors did it intentionally? That she'll disqualify them? Because that's really the big ask. So thank you so much for the super chat and of course the food for thought. Garrett S says, Tom, Wayne, even Marsha, Brady lives matter. And then we're going to go, let's pull up this transcript. Oh, and actually, let me do it in this view. This is a little bit easier to see. All right, so. And remember, this transcript would be Love's own interpretation. Because that can make a difference. So here, she starts getting right on the first page. She gets into her second concern. This is Love speaking. So she has a concern that I don't know what advice counsel may have offered or may have been offering. That is their right and their business. But you didn't care that he had counsel, but okay. Let me not do flashbacks and revisit this whole transcript with what we know now. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of this statute, and we heard him say in court that he knows what use immunity is, but didn't know that this was the statute number, like, directing it. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shart with me and Simone copied where he said, this is the communication that I received from Ms. Love regarding Mr. Copeland. My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which clients are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shart's? He wrote back and said, you're going to get him killed. You have made him, you're making him a target, F you. That is what he wrote in the email. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, his concern has nothing to do with exposure from the state. So Melnick isn't raising a fuss about this testimony because of the state possibly exposing Copeland. We're not the ones that are going to hammer him. And if his concern, his being whose concern, so Judge Glanville's like, who? And Love is like, Mr. Melnick, the attorney we suddenly just found out about. That attorney we didn't know about. If the interest that he is protecting is Mr. Copeland's freedom, meaning not holding him in contempt, which is different than exposure that would get him prosecuted. Love is saying if the interest is protecting Copeland's freedom to not be held in contempt, he didn't convey that by asking us what exposure does he face in testifying. So here I think Miss Love got her intentions confused with what she wanted to say out loud. In fact, if he's concerned that testifying will get Mr. Copeland killed, and he is not communicating with us, he's communicating with counsel for defendants, it would seem that he knows a thing or something that we don't know. So we start this whole issue. He's communicating with all of us through email. I don't know why all four of us are named on it. But then it suddenly becomes, he's not communicating with us. He's communicating with counsel for defendants. So he injected himself, but he's also not communicating with us. Like, come on. This is more annoying every time I read it. Oh my gosh. My gosh. Yes. Yes. And I don't like to call everything gaslighting. I think it's an overused term. But boy, do I feel like that when I'm listening to Love make arguments sometimes. Oh my. Oh my goodness. But yeah, it would seem that he knows a thing or something that we don't. But, okay, so we know that Love has been screaming and trying to pull her hair out about reciprocal discovery from the defense that she's not obligated to receive. They're not obligated to turn over. But she's trying to argue that the defense owes them reciprocal discovery. The judge isn't buying into that. We've heard her response orally. And then we're saying it would seem that he knows a thing or something that we don't. But then we also have Hilton later saying that she knows everything about Copeland and knows he didn't do something else, didn't commit another crime. So if you are arguing that you know everything, how are you also so paranoid and arguing that there's something that you don't know and the defense are in cahoots and covering it from you and not disclosing something? Like, this is like one paragraph of like 5 contradictions. Oh my goodness. Additionally, and I will let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland. So that's her language here reciting this. That's her language. And remember, Kayla has also looked at this transcript. She read a bit of it on her channel. So this is why I think it's very, very good that the judge says, let's just ask Melnick. We know we did hear yesterday that Melnick, look, if he's going to go up there and continue to plead the Fifth, he wants to be discharged. He wants to withdraw. And we know that on June 10th, maybe it was the 11th, I think it was June 10th, we know that Kayla, during a lunch break, went and got the form for herself so she could withdraw, she could be discharged, Copeland could sign off on it. But her situation was different. She was only there to stand in for that ex parte meeting, to deal with the issue of contempt. And once he purged himself by getting back on the stand and continuing to testify, her services were no longer needed. And it was almost like, my read on it, this is my subjective opinion, is if Kenneth Copeland got up and said on a YouTube video that he's still cool with Kayla, it seems like I'm firing her because they're just not letting her leave, right? So that's where I come to the conclusion on that, and why it's only Kayla that Judge Whitaker is aware of any paper being signed, actually being signed. And Love panicked. We watched that clip with Woody. Love panicked. Oh, we think there's one for Melnick too. Well, there may have been a discussion of someone giving them the paper for Melnick to discharge himself. And Melnick at one point seemingly may have wanted to stop representing Woody. But if circumstances change, because either Whitaker is going to appropriately not advise, but make sure this immunity is properly explained to Woody, Woody knows what he's up against as far as contempt, maybe Melnick's willingness, maybe he won't feel like this is such a noisy witness situation anymore. Maybe he'd be willing to stand in the court. I can't make that prediction until we know for sure what Woody wants to do and if we see Woody say anything. But this could change the whole course of the game, and there's no winning for the state. There is no way that the state can get a win with this. They don't want Melnick there. They don't want Copeland to be uncooperative. I'm sure they don't like the judge correcting them on their definition of, risks with use immunity. Like, come on. So she goes on to say, if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem that you'd want to be there for him while he's testifying. And then Glanville, with the assist, comes in and says, well, he's on vacation this week. I understand. This is why he has Miss Bumpus here. And he has said what he has said. And I've said what I think he said, because we know she didn't characterize these emails correctly. So, in a way, this quote of, if Mr. Copeland testifies, we could be getting this quote confused with Melnick saying, if he pleads the Fifth. We could be getting this quote mixed up because of telephone game with this transcript of Love's characterization of what Melnick said. And Kayla could be relaying the same thing from recall. So the judge is right. Get Melnick to tell us himself. I don't know if you guys wanted to read any more about the transcript, but that was the relevant part, the part that I was thinking of. And I was also thinking of a hypothetical from Ashley Merchant, which I really wouldn't be surprised if Love had seen this. But back in July, Ashley Merchant had said the fact that neither the prosecutors or the judge, meaning Judge Glanville, knew what was going on is somewhat terrifying. As soon as a criminal, and this is a hypothetical in general, as soon as a criminal defense lawyer says, if my client testifies, I am withdrawing, anyone who does this work should immediately know that this is a noisy withdrawal. A noisy withdrawal is when, and a noisy withdrawal can be more things, like the prosecutor or Linda Johnson in the Rush trial when she withdrew. That's also a noisy withdrawal. But here in this particular situation, a noisy withdrawal is when you believe your client, by testifying, will be potentially committing perjury. It is literally signaled by the words, if he testifies, I'm withdrawing. Belove, apparently in her own legal world, accused the defense lawyer of not protecting his client. She said, whose interest is he, Melnick, protecting by withdrawing if he testifies? His clients or the defendants? She kept repeating that. She asked for this ex parte because of her concern over whose interest Melnick was protecting by withdrawing. Love told the court that Melnick was withdrawing if Copeland testified. Immediately, the court and counsel should have known what that meant. Melnick was doing his ethical and legal duty by threatening to withdraw if Copeland testified. Court and counsel should have immediately figured this out, but instead, Love kept accusing Melnick of having conflicted loyalties. So, little flashback there, you guys, from Ashley Merchant. And we'll get the court screen back up. I know, we actually have a ways to go. Because I said 1:30. But still, just in case. And yeah, so Kedrick here says, intentional or not, they coerced him. The judge said it. They are professionals and should have to pay for their actions. And these are professionals that are teaching courses. They are the mentors for the next line of people that could enter into some, maybe they won't become prosecutors. I think they're just doing legal education law courses. But people entering the field in general, whether they become prosecutors or criminal defense attorneys, these are the people educating this next generation. So if they're in that role and they're educating people, they shouldn't be ignorant to the things that they're supposed to be teaching. They're experienced and they play the position of a teacher. And they're getting this wrong. So it's either gross incompetence, or it was intentional coercion because they just wanted to compel this witness to testify. And neither of those are good. Miss Kim, thank you for the super chat. Kat, you should consider law school. You are the truth. But I stumble over my words. I'm really bad at arguing. I like to talk and think. I'm so bad at arguing. I would never want to be in the position where I have to go up on a whim and improv at the podium and make my argument against someone else. I just don't think I'd be very good at it. But it's so sweet of you to, with the encouragement. I do want to keep learning just because. So Stay Tipsy says, remember in the beginning, Miss Love coerced the judge by giving false information about how long he can sit in jail for. Then the judge relayed it. Yeah, so we just looked at that part of proceeding, leading up to that part. We can pull that back up. Let me search it and I'll pull the transcript back up. Okay, I don't know why it took me so long to find this page, but here we go. So looking back at because I think I wanted to see, and it looks like this may have been Hilton. Which is still, guys, to me, it doesn't really make that much of a difference if it was Hilton or Love because they're on the same, they're both the state. Yeah, so Kayla's trying to walk through it. There we go. Okay, so this is where it starts. So from Hilton, They're trying to figure out. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came and then we had court. And Kayla says, so you're pretty much saying you didn't ask for this? Woody says, I didn't. And Hilton says, but we gave it. He doesn't have to ask for it. Kayla says, I know. I mean, he's just saying, Hilton, right. He doesn't have to ask for it, but to alleviate whatever his concerns were. Whatever. We gave him immunity. So we don't care what your concerns were because we know what we want out of you. He didn't have to ask for it. Miss Bumpus. So if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking it through. Miss Hilton. Miss Bumpus. Would he still have to have had to testify, or would he have been able to plead the fifth? That's what he's saying. Hilton. If he did not have immunity? Kayla. Yes. Hilton. Yes, he could plead the fifth. Copeland. That's what I'm... And then Bumpus. That's what he's trying to say. He's trying to say he didn't ask for this. Hilton. But he doesn't have to ask for it. Now that we've given it to him, because that's on us. So now that we've given it to him, it's an order. He can still choose. If this is the road he wants to take, then he'll just stay in custody until the trial's over. And when we say the trial's over, every last defendant has been tried. Not just these 6, the other ones too. Copeland. I've done longer time. Miss Hilton. All right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record the state does not want you in custody. What the state would like you to do is purge yourself from... What purge yourself mean? Meaning that you are no longer in custody. And the way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way. But we don't want you in custody. The only thing that's holding you is refusing to testify. Judge Glanville. So do you have any questions? Any other questions? Basically, if you invoke the fifth, Copeland, I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor. And we heard, I think Copeland said himself that he was referring to Kayla. Miss Hilton, this is your insurance. I don't know if you want to break that down to him. Miss Bumpus, well, he doesn't want that. Judge Glanville, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is that they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made, from the state's perspective, they have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference. And then in this particular scenario, they've taken that away. You can still invoke your Fifth Amendment privilege. You can still do that. But the consequence of invoking is you will just remain in custody. If you testify, you get out of custody, and you stay out of custody until you're done. And then Copeland asks again. And then if I don't testify, I have to stay until when? Until the trial's over, until all the defendants have been. I've got these 6 that we have right now, and then there's another 6. Hilton says, no, there's another 12. Judge Glanville, there's another 12 or thereabouts that are still outstanding in various forms or another. And then Copeland wants to speak with Kayla. So revisiting all of that, definitely remember that in the beginning. And I do want to clarify that I'm sure Love is on the same page, but this conversation right here in the transcript was between Hilton. Love wasn't in the room anymore. Love is on the same page anyway. They're operating on the same team. But still, like, this is it. This is that thing. They apparently did their homework to see if they could find a way to convince him to testify. And Whitaker's challenging them today. Like, I don't think that that's right. Your subpoena is for this case, not for the cases for the other co-defendants. It's great. Thank you so much, Stay Tipsy. It's great to revisit that transcript now. Patrick Taylor, why does Love sound like every arc is not hers and can be written by chat AI law system? Well, I think it was it the hood lawyer? I think the hood lawyer on X clipped the screenshot. Or he like took his phone out and was recording. I think he was projecting the trial stream on his wall. And he took his phone out and recorded and zoomed in on Love's screen, and it was on that AI legal website. So, Patrick Taylor, to answer your question, thanks for the $9.99. It might sound like a chat AI law system because she was using that. She had it open. So, there you go. Nick Starro, thanks so much for the Corona. Kat already knows I'm sniping over lunch. And no, that's okay. You're always welcome to stream snipe. Or like use the water guns because, you know, we got to keep it PG for YouTube. So snipe away. We're raving to you over here. And then Nancy, great point. So Nancy News says, Melnick couldn't put his bar card on the line with Woody testifying, knowing he would lie. That's why he advised him to plead the fifth. And I think we're really going to get major clarification on this from Melnick today if he's able to come in. I want to see somebody, and it might be Whitaker if the defense doesn't get the question first. But imagine if it's Judge Whitaker herself that asks Woody, you know, back in June, when you were meeting with Miss Hilton one-on-one, did she ever ask you if you had an attorney? Did you tell her you didn't have an attorney? And I'm not going to lie. It could be possible that he really did tell Hilton that he didn't have an attorney. And I still don't know why they would have already been in a point where they're having a conversation with him before they looked at the records and tried to reach out to Mr. Melnick first to see. So Copeland saying that doesn't exonerate the state from not trying to see if he had counsel first, because they were already meeting with him one-on-one before they made the inquiry that they could have made through the court records. But at the same time, I wouldn't be surprised if we find out that Woody was using that to play Hilton. And Hilton thought we were building great rapport or whatever she said. So I definitely think Melnick is trying to do the right things. Attorneys have a duty of candor to the tribunal. They're not supposed to put someone that they know is going to lie on the stand. And sometimes that can be tricky, right? You don't want to get into attorney privilege or conversations you had with your client to let the judge know why you feel like you need to withdraw. But a judge should understand, especially a chief judge like Landville, someone with experience and a standing, should understand what it means when an attorney says they want to withdraw. But can't really give you the exact reason because it would divulge, it would include divulging attorney-client privilege information. So I don't know. Definitely not worth risking a bar card just to, you know, honestly put your client at risk. Because that's the flip side, right? If it would be unethical, it could be something that also would convey risk to your client. So all of this fuss from the state about he's not looking out for his client's best interests. Well, if he's saying I can't properly represent him because I don't know the context of it if he's planning to do this on the stand, his concern seems to be I can't represent him well, which seems to be in the interest also of the client. So Nancy New, you're on point. FFS says, Love really doesn't Woody want Woody to have the benefit of having an attorney while he's on the stand, which I really don't think he will even testify. He had me dying laughing right from the start. Yeah, and I think it's going to be that same thing all over. We just tried to go through all these evidentiary issues relating to the jail calls for Copeland. Today we've been talking about Zachary's statements, but a little bit yesterday and then last week, we're going through all these, you know, June 10th from 2015, all these calls. What can come in? Just possibly for Woody to get up there and just, I don't recall, not lay any foundation. And we're going to, even though we're rewinding some of it, the state's going to be stuck. I don't think Woody's going to give them anything to lay the foundation that Whitaker's going to look for. And then Kedrick, do you think she's enjoying the tension, kind of like Glanville? Why hasn't she ruled on the mistrial yet? I think she's actually considering them. She even specified earlier today, and maybe I'm getting my days mixed up. Maybe it was at the end of the day yesterday. But she's already written a response to some of the arguments. But she's still looking at a few of the arguments. And she pointed out to Love that her oral response today this morning didn't address some of the outstanding arguments. So I think she hasn't ruled because she's waiting to write on a few arguments. She's looking at if there was a Brady issue. She's looking at, was this a critical stage of the proceedings? And if rightfully the defense objects to rewinding completely and starting over with Woody. And we have to keep this immunity in place. We don't redo any meeting about the immunity order. That means we can't redo something that was probably a critical stage. I think she's considering legally that that was a critical stage of the trial because he was sworn in. If the defense gives a valid argument as to why we can't rewind all the way and redo all of that, then there's going to be a frozen part of the trial that was a critical stage that the defense was excluded from. And the state has not countered that argument. They touched on it in an earlier motion with like a paragraph and a half, but they didn't touch on it with the renewed motions from Shard and the oral arguments from Shard. We'll see if they do on Friday with their response. But I think she hasn't ruled on it because of those two arguments that I don't think the state knows how to address. I don't think there's case law because I think they were wrong. So I'm excited to see the response. You guys mark your calendars for Friday. We will definitely read that response. It might be late if the state files it last minute. You know, we might be doing that at like 6 p.m., 7 p.m. on Friday. And well, Nick Starr's probably doing a panel, so maybe that'll coincide with the right time. So we'll play that by ear, but we definitely need to look at that. And then Nara Alexis, thanks so much for the super chat. And then thanks for becoming a member, FFS. And then Nick Starro, so Carr v. State, regarding mid-trial Brady. Yeah, let's look that up. Ugh, I hate that it doesn't let me copy and paste. Sometimes it does, sometimes it doesn't. Let me just type that. Okay, we've got like 20 minutes, so. And how long is this? So let's bumper this. We'll look at the first, because sometimes they'll give you a brief right at the beginning and then right at the end. So Supreme Court of Georgia, this appeal is from Weldon. This appeal is from Weldon Wayne Carr's conviction of malice murder and first-degree arson. Carr's wife died in a fire in their home. He recounted to authorities that he awoke and realized there was a fire downstairs in their home, that he tried to get his wife to escape with him through a bedroom window, but she resisted and tried to go towards the fire, and that he lost her in the smoke and confusion after a struggle, but finally saved himself by jumping out of a second-story window. The state's theory of the case was that Carr set the fire, then injured his wife so that she could not escape. Although she died of smoke inhalation, Carr's wife suffered other injuries, including cerebral bleeding, and prior to the fire, the couple had been experiencing marital difficulty and had been seeing a marriage counselor. Ms. Carr was having an affair of which Carr had learned, and she had told several persons that she intended to divorce Carr and marry her lover. In a short period before the fire, Carr engaged in conduct which appeared suspicious after the fire, checking on fire insurance, getting copies of his and his wife's will, telling their adult son, who resided elsewhere, to remove some of his belongings from the family home, putting valuables into a safe deposit box, and conducting an uncharacteristic spring cleaning of the house. To support its theory that Carr used an accelerant to start the fire, the state presented evidence that burn patterns at the site of the fire's origin were consistent with the use of an accelerant, and presented testimony that a dog trained to indicate the presence of chemical accelerants had alerted at the same site. So that sounds pretty like the dots all line up, right? On appeal, Carr contends the trial court erred in the following ways: permitting evidence of a dog alerting to the possible presence of an accelerant as substantive evidence of the presence of an accelerant, ordering certain pretrial discovery, admitting into evidence inadmissible hearsay testimony, improperly admitting bad character evidence, excluding defense evidence regarding the reliability of a dog alert evidence, erroneously qualifying witnesses as experts, permitting testimony tainted by a warrantless search, refusing to record the entire proceeding, and improperly limiting the evidence presented on motion for a new trial. He also contends his convictions must be reversed because of prosecutorial misconduct, and because the evidence presented at trial was insufficient to support the convictions. After a review of the voluminous record and the extensive argument of counsel, we conclude that the convictions must be reversed for the reasons as follows. Now I'm going to see if we get, because there's a few arguments here. Was it late disclosure? Let me see. Oh, I'm in the search bar for the window. Wrong thing. So let's see. Maybe this is the argument relating. So in accordance with Sable v. State, the trial court ordered the defense to disclose to the prosecution the results of all scientific tests and experiments conducted by the defense. Carr complains the order had a chilling effect on the development of his defense, and that he forewent certain testing because he could not be sure in advance that the test results would be positive for him. In Rower v. State, this court overruled Sable to the extent that it gives the state any discovery rights greater than those specifically granted to defendants by OCGA 17.7-11. Although the Sable order in the present case was correct when it was entered, Rower was decided just before the trial began. Thus, this case was in the pipeline. The Rower rule applies. And this was an error. And that's Childress v. State. The state concedes that the order was erroneous under Rower, but contends that any error was harmless. Because we find it necessary to reverse the convictions in this case for the reasons stated in Division 1, and because the tests were conducted after the trial, and Carr will have the use of them for a retrial if there is one, we need not decide whether the error ordering full disclosure of the results of all tests and experiments conducted by the defense was harmful. Did we get a misconduct one? It's long, so I just want to get to the... Oh my gosh, this is a long... This is a long paragraph, Nick. This one's long. This is long. I think this will cut us into the trial. So I'm going to paste this in here. This is what we're looking at. And then do want to make sure we're back up over here. So I do love some case law, but I might want to read that in full. But yeah, that's interesting because it's Georgia. That's right from Georgia. So, it's not like we've seen some other case law come in where it's like, in Ohio, they said this one time, and it might be pending an appeal, but right now it still stands. And then FFS says the foundation to uphold this is being broken down harder than the heels on Love's salamander pink shoes. Those were like salamander pink, salmon pink. I have a notepad here. They're kind of like this color. Oh, that was so funny. So we have the ice cream cone. It could be like a drumstick. Like how the drumstick puts like a little bit of the chocolate in the bottom of the ice cream cone, but it can be strawberry if we put the shoes in too. It was a Cash Money Cass had said earlier that her outfit looked like a strawberry cone. Thank you so much, FFS. Ray LF says, I would love to know why Miss Love is so adverse to Melnick being involved. I mean, there could be personal animosity there, but the number one reason to me would just be that Melnick was making an argument.
Okay. Carr v. State. This is the part I try to convey to Kat to read. This is about the blood test evidence, which comes in, which is later, and that is what I wanted her to read. Nevertheless, when the state introduced the testimony of the toxicologist as to the result of the blood test, Carr made no objection. Instead, Carr waited until after the state rested its case and then moved to strike the toxicologist testimony on the basis that the state failed to prove the blood was withdrawn by a person qualified under OCGA, blah, blah, blah. By failing to object when the testimony was offered, Carr waived any objection which he could have made. It is well settled in this state that it is too late to urge objections to the admission of evidence after it has been admitted without objection. Although a party may move to strike illegal evidence any time before the case goes to the jury, even where no objections was made when it was admitted. The result on the blood test admitted in this case without objection, despite the state's failure to satisfy the foundational requirement that the blood was withdrawn by a person qualified, was not illegal evidence subject to a subsequent motion to strike. There was no challenge to the validity of the blood test results, although the state's failure to lay a proper foundation by proving the blood was withdrawn by a person qualified affected the admissibility of the test results. There was no evidence that the probative value of the test was in any way affected. A distinction to be drawn between illegal testimony and secondary evidence or other evidence which is legal in itself because of its probative value but is inadmissible until the proper foundation for its reception has been laid. Patton v. Bank. So that was the part, Carr v. State, 222 Georgia App 776. That was the bit I wanted Kat to go through. But we didn't get there. So there are rulings in other cases where it is said that where they have concluded that mid-trial Brady violations might still be admissible as evidence since the defense had knowledge about it. I've seen a few cases, but the statute, in my opinion, in the Carr v. State does not allow it to happen if there is an objection, which happened here the moment the defense knew about it. So that is why I believe the Carr v. State statute does not apply in this case. Whew. Let's go up there for now. Hello again. We have maybe 10 minutes before. I will try to get that through to Cat. All right. Oof.
That in the ears, and was that Hilton that said it, or was it Love that said it? Love was so focused on clearing up a misconception about her, possibly. Okay, and I just see Kayla. Okay. So hey, Kayla, I think I'm jumping into a random conversation because Kayla's saying, yes, his son was my intern when I was DA. So maybe we're talking about Glanville. I don't know for sure, but I'm just going to piece these two together.
Yeah. If once it's confirmed that he would go to jail for the rest of these trials only, it's a wrap. He's going to jail. Problem here is the judge might conclude that there is enough about the Donovan Thomas murder in order for the jury to make a conclusion. My problem with that is without Woody, there really is nothing that connects the defendants to this alleged crime, unless they find a cop or anything that will try to make the argument, or if they magically finds the reports again. But it doesn't mean this RICO case is over, because there is one more murder charge. There's one more. So it doesn't relieve. But if the second one also goes out, then in my personal opinion, if the 2 murder charges is gone, they can convict on the underlying or the other charges, because everything else, the statute of limitations has run out. So it's not out of the realm of possibilities that the judge decides to go to a directed verdict on a bunch of these, especially the Donovan Thomas, if Woody pleads the fifth and goes to jail. I saw this earlier. Thank you to Steve Keat for your New Zealand $10. Thank you so much. Okay, now there's only 6 more minutes. I need to... I'm still doing stuff in preparations for... Because in less than 12 hours, my flight leaves from Copenhagen, and I'm on my way to the United States. So I still have some stuff I need to do. 6 minutes. 6 minutes. I guess you have to... Well, have to. You don't have to do anything. But let me play some better elevator music. right. There she is. Sound is on.
We got everybody? All right. All right, what I know about Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation. All right. Yes.
Use the
Am I
damn
cold?
microphone.
Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up a half a degree for y'all. And then if y'all, hang on. Now, there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay.
I'm rarely cold. I have a good insulation layer.
All right, so we were, I think, on item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment, which was to look up the law and to look up what we should tell Ms. Copeland. I don't have.
oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have a copy.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute,
Raising the sound a bit more.
so just the plain language of the statute, Your Honor, which is essentially a statute not saying that the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take. And in.
Hang on a second. Can you not hear her?
Yeah.
All right. Can you, I don't know. Do those mics move?
It wasn't on.
Okay.
It wasn't on.
There we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so Section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in Section A refers to both, and it talks about the fact
That means, in plain language, it's up to the judge's discretion.
that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference a trial jury. But given the fact that the statute itself refers to them almost interchangeably in Section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I haven't fully got it. It's in Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
And in
And it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's.
You was sent the case
cited
or
in the
AI?
limitations.
It is for a different proposition. I haven't read it myself either, but
Oh, please, please let it be an AI case that doesn't exist. Please. I would be so happy. I would be so, so happy. Lois Thomas, how could he get out of jail between trials?
I don't know that this
He started
case
testifying.
really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on the point, however, it would make logical sense that it couldn't go past the end of the trial, because how would Mr. Copeland purge himself of contempt at the interim time between two trials?
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available. I'm
It was not going to be available at, I mean.
not at that trial.
Right.
That was less, yeah.
So I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
Your Honor, I know that the court did advise him that this was. Westmoreland, can you hear me? I know.
One thing is, to Judge Glanville and to him, she asserted that Woody could be held, or if it was Hilton, I don't remember, that he could be held. And even Judge Glanville said it, that he could be held until the conclusion of all the trials. So back then, she asserted she has to have case law. And here she is with zero case law. So this was just a threat that wasn't substantiated in law. That makes it per se coercion, in my opinion. I hope the defense will bring this up.
That the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified the last time, Judge Glanville, I think, gave him a copy of
Miss Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think
in court.
Yes,
Okay.
he gave to Mr. Copeland read to him or gave it to him a copy of the statute and apprised him. I think he made
Right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
Yeah, he was read that on the 7th.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I was surprised.
One of them.
So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was Well, who knows? But that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page,
Yes,
at
John?
10:03,
What is
and it goes until 11:30, and I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but, I mean, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. Right. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to
Avoid politics in chat, please. This is trial stream. We handle crimes, not politics.
to read him the statute and then respond? I don't know. I'm asking. Respond to questions because, for instance, I even heard, it may have just been a misstatement, obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, that was in there from the start. And
All right. And, yeah, do you want to, I can, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel, so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
And I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but
well, maybe we can dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not who knew what when and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
You're beyond it. Great. We'll see if he is.
And I would love to be able to fully explain, to allay any fears that he has or concerns about his client's criminal exposure. But 161070 is the perjury.
Okay. And then I ought to know prior inconsistent statements by heart, but which one is that? 24 something? I don't know. I'm sure I have it in front of me somewhere, but I think those would be the four relevant things: the order 507, perjury statute, and prior inconsistent statements.
All right.
I'll figure it out later. I can find.
I have to go attend to stuff, so I really can be prepared for my flight tomorrow morning. I will keep playing this, and I will return when Melnick is on the stand, because I do not want to miss that one. Okay, see you in a bit, folks.
Prior inconsistent statements.
24-6-630. Wait. 24-6-613. Witness's prior statement. 24-6-613B.
So Ms. Pursfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but.
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that. Yes. Yes, I don't, who said that?
On that topic.
You did what? Say that again.
There should be an email.
Okay, to Ms. Pursfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. The U.S. Supreme Court cited in the footnote 1, it's from the Middle District of Tennessee. It's our issue. It was a deposition. The person refused to testify. There were trials coming up. They were not set yet. The government's position is like the state of Georgia.
The government's position is like the state of Georgia here. Just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And then the footnote they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against a person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point, they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, really, according to Ms. Love's reading, we could just hold them until it's 50 years
die.
later. Yeah.
Yeah.
I mean, at
Which
some
can't
point,
be the law.
And Judge,
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure. Did you send
I
it
got
to
a copy.
everybody?
He did. I got a
Okay,
copy.
yeah.
I just want to read it.
and Judge,
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of Banks. In re estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party, because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed. So that answers the question for me. You can look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right, so.
That means they can't hold Woody in contempt indefinitely. Only this trial.
I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even. Okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying about that.
And, if you then say.
If she agrees with what the court says, I would argue she knew it all along, which means she knew in that ex parte meeting that she lied to Woody. See you later, Bob.
I don't know, I don't remember, blah, 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 to whatever. every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, you know, sort of when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it. Either way, if y'all are fine with me winging it, I'll wing it. But don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I mean, I inquired the court regarding the court's earlier statements about the case that Mr. Mack cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be if you've said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that is my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean to this part of it. Okay. All right. So let's go back to our narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachary.
John, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a layperson, Mr. Whittiers, navigate his way through these things. So I would agree with the court's inclination.
Okay. And if for whatever reason, a public defender or conflict defender cannot represent a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, but if they can't for whatever reason, then I don't know, we just have to.
Then I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested in Mr. Copeland's testimony than either either side. And so I think it would be the court's responsibility at that time.
Well, it's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and
Sure.
put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
Good.
all right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here. All right, are we ready to turn to our potential redaction number 20? Should I take silence as a sense?
How about resignation? Because,
Yeah. Fair enough. All right. So, and whenever Mr. Melnick joins us, we'll just take a pause and let some deal with that. All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I've uploaded, I've neglected to inform the court, I uploaded to that Dropbox link, the recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, sure.
Okay.
I try to keep the same link for the transcript, so I will resend that link, and then there's one long version of the video, and then there's a smaller one where it breaks it into smaller chunks. I've used VLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
Okay. I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me.
I recommended that he's in the smaller chunks, the bigger chunks have a harder time.
Actually sending, yeah. All right. And is this hearsay?
So, part of it, Judge, what did you, starting.
So we're at 75 line 10 through whatever the next thing is, 70. Where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day. Zachary says that's when their spot got shot up. That was the next day, though. You're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Lucci's mama's house got shot up, and Zachary says, yeah. And Dennis says, right. And Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing the proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in, and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as,
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased. But, oh, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or down through more, it looks like.
Well, then they
Through
start
78, line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21, that's page 79, line 14 through 22. Speculation about who shot at Thug's stepdad's house. Hang on, 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, I mean, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list. The latter, page 79, 23 through 24. I have no objection to page 80, the entirety of page 80. What are we going through? And up through page 80.
They're saying 81, line 5. Let's deal with that. I mean, that all looks like.
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
Is that supposed to say?
I can go without that. So
All right,
1
so-
through 5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81, line 13 through 82, line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. I just, my problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through
Yeah,
Investigator Dennis sharing information with Mr. Zachary.
yeah. Okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those,
Okay.
videos with you.
All right.
So I was.
That's okay. So we're talking about 81, line 13 through 82, line 3, and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
no, yeah, through, sorry, no, through 82, line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83, line 18 through 84, line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88, lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement, it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, my client, went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting, so.
Well, people in Cobb County would be interested in that, but.
Okay, well, I don't know. I mean, maybe they're just saying that to see what he's going to say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it, though.
Yeah.
So to the extent that if he witnessed a cars leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay, do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you would literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay, and I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have.
So is Mr. Zachary in a second car that's involved in this?
So he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
in that compound.
right.
Everybody shows up at this one place where
Yep.
the plane is in about 5-6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour
Okay. But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
Yes, he
Okay.
says, Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting DK and Shannon, if he's crossed on that, I would argue that goes to its weight, not its admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary, it sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't want the other.
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that? What's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I've heard him say, you know.
Okay, so then by agreement then,
Just mine.
well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about,
So, but 5.
how about that? I mean, the 5 through 9 I see as kind of a one little answer that he seems to be able to know. They say truth was with them. Well, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's not here, on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome to, I assume it'll show up on, does it show up on that big screen? All right, so y'all can just watch it on the big screen.
Are you ready for him?
I am. I think, I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure
So,
we
Judge,
clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us?
Here
And
we
if he
go.
has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
Yeah.
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just here.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
When do you propose I ask him? Because if I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed.
Okay. All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or
Miss Love is scared shitless about what Woody may or may not say because she knows, I believe, that he can say anything on the stand. Absolutely anything. Miss Love, you should have worn brown pants to court today.
I do not care, throw me in jail, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection.
It was just the timing of it.
So would you rather I do it Friday? I mean, I don't understand what it is you want me to do.
It was a preference, but I'm going to, of course, defer to the court. It's just, as I work through everything that I know has taken place, I'm just trying to make certain that the interests of everybody are protected.
Okay,
I'm not trying to create a.
No, I understand, and I mean I'm just not sure what else I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So Mr. Melnick.
I put up a poll. So the alternatives are prosecution coerced me. I unalive Donovan. I don't remember. Those are the alternatives. Vote.
You weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter, because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway. It's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
If you think
Certainly he does.
Okay.
Woody have
Anything
listened
else y'all can think
the
of
entire day, press 1.
on either side
If you don't,
of the aisle?
press 2.
Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential
This is so
issue, Mr.
beautiful.
Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay, is there a screen where he can actually see Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in.
Woody, have you had time to say to your kids, I will see you in a few months? Have you kissed your wife goodbye? Have you done all this?
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth. And in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay, does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
this one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions?
Mm-mm.
Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice, whether to take the stand and be questioned and cross-examined or not. Knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied and lied and
I
lied.
know. And,
So how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're going to be able to charge me if I lie. Like when they just up to them to choose when I'm
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that you know he didn't do, and well, maybe not. Never mind. Don't do
Can I
that.
give you an example for what they told me?
Yeah, yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Plead the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you can then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they
formally call it.
they facts together? Like they saying something they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay, so what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I'm not getting on the stand?
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now.
Okay.
All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
Okay. So,
All right. So there we have our answer to the extent we have an answer.
We have no idea what Woody will do, which is exactly where we were before. Nobody knows what Woody will do, not do, say or not say. We have no clue.
We will revisit this on.
What we do know is he will have a weekend with the family to discuss this. We will find out Monday, I guess.
On Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are. Okay, back to Mr. Zachary's testimony. Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Okay. That was it's Woody. What can we say? We can't predict what Woody will do. What will Woody do? We will find out Monday. And Monday is the 12th. Monday I will be driving to New Orleans. Yeah, Monday I will be driving to New Orleans. I can't, if I get there to New Orleans early enough, depending on, yeah. This is rough. I'm not sure. Just let's say that I'm not sure if I can live stream this on Monday. It depends on where I am. But I will be leaving Houston early Monday morning. But it is a 5-hour drive. I might not be in New Orleans until lunch at the earliest. So I can't say. Yeah, I think there's a risk that he will spend the rest of the week and the weekend with his family. And then plead the 5th on Monday. Is it a 5-hour drive? Okay. then yeah. So I need to have breakfast that morning at least before I drive off. Now, my mornings usually starts 4:30 a.m. I don't know if I'm still jet lagged or something like that, but I would imagine that if it's on the 12th, I'm stopping at Buc-ee's. The I-10 from Houston to New Orleans. Louis Thomas says traffic on the 10 is terrible. Will probably take you longer if that is the interstate you plan on taking. I plan on taking main roads. But if I start driving 7 a.m., I should be out of Houston at least before the big traffic kicks in. Buc-ee's in Baytown. Where's Baytown? Okay, that is just outside of Houston. Buc-ee's. What? Oh, it's open 24 hours. So I can drive there really early and get a really early breakfast. Yeah, that sounds, 30 minutes east of Houston. Well, I can get there in the morning. I can video myself being there, put up the video on both for members only. It will be so you have to be a member, or you can go to my road trip channel. Let me post the link to that one. I have to separate my trial streams crime stuff with the road trip, because if YouTube believes I'm doing crime and road trip, the algorithm will be focusing on people who likes road trips and crime. So I have about 400 serial killers. I don't know. Conditionally accepted. Not heavy traffic going east. Okay. There it is. Here is my road trip channel. I have posted a few videos, 4 videos on that channel. So you can follow me there or become a member and see it here. They are not back yet. Now, what was the poll? Last place, Young Alive Donovan at 6%. At 18%, I don't remember. 36% pleading the fifth, and 39% prosecution coerced me. And the answer was none of it. We will find out on Monday. Crime and road trip. I mean, I will be visiting the Atlanta or Fulton County Courthouse on the 14th. That I can stream or video and put up on this channel. The other stuff I will be doing in and around Atlanta, I mean, I heard something about an aquarium that I want to see and stuff like that. But 14 to 15, I will be in Atlanta. Conditionally accepted says alcohol, tobacco cheaper in Louisiana. Yeah, I heard about the Texas morality. You're not allowed to have fun law regarding alcohol and tobacco. Now, I use these nicotine pouches, but I do smoke cigars from time to time. But I'm only allowed to bring a certain amount into the United States. I use one of these per day, and so I can bring maybe 10 with me, but it's a 17-day road trip. So, yeah. And here's the thing. If Fannie Willis or Miss Love sees me in Atlanta, there might be a risk that they will throw me in jail. I might have said words. But if you want to send me bail money, preferably via PayPal. Going to lose cell service between Houston and NOLA. I've heard about that. I will have a separate phone with one of these tourist 30-day, what's it called? Many calls, endless wife, whatever it's called. But it's not the unlimited. That's the point. It's the speed that is the point. So in between hotels or people I'm going to visit, streaming will be quite hard to do. No state income tax in Texas, so tip for that. Yeah, but I don't pay tax at all. So any sales tax, yeah. Yeah. Miss Love had the audacity to object to the judge asking him if he will testify. Miss Love, from the mouth of Renee.
You stupid woman! You.
Everybody heard that?
Stupid woman! You stupid woman!
Jim Cox set up a remote into your PC. I have no idea how to do that. Old. Maybe I can ask IT Goatee on how to do that, because I have fiber broadband here. So if I can do it, sure, I will have to ask him how to do it. It's just, how do I do it? They are still not back. I have a few more things to attend to, because it is 9 p.m. here now. The plane leaves 7 a.m. in the morning. I have to be there a couple of hours beforehand to be on the safe side on the airport. So in about 6 hours, the cab will get me to the closest city center, and then I will go by train to the airport. Set up streams ahead of time and just start the broadcast from mobile. Yeah, but the broadcast will be through the mobile phone, even if I set up the stream. But that it has to be that remote thingy, because if I keep the computer on here and set up everything here, you mean? I don't know. I have to ask IT Goatee. How to do that. But I have more stuff to attend to. So they will be back from this break anytime now. And but I have to do more stuff. Have fun. I will be in and out. You will see me here, up here in this corner from time to time. But I need to get ready for the trip. Okay, see you in a bit.
Okay. All right, so I think we are on page 90, lines 11 through 14. Okay.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Mm-hmm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. And my notes I have on 90, line 14,
Mm-hmm.
Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just,
But yeah. All right. What does the state say?
Your Honor, it's a question,
No.
it's not an assertion.
No,
They're
it's
asking is
quiet.
Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
We can do that.
then also I'll bring it to your attention that
Talk into your mic, please.
on line 21,
Yes.
Investigator Dennis, my notes say, where it says indiscernible, says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
And let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well, but right now we're just making it right.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and
Well,
going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
like I hear this voice who is talking. All right.
It's God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right, and
based on everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they've provided thus far.
Okay.
And we think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the, legal reasons for or against. But okay. So if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not gonna be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're gonna do this, we might as well listen to both of the ones, and I don't care which order we do it in, but. Y'all can go ahead. I mean, look, is the video matched up with the audio when y'all are? All right. Sometimes it
I don't know why I get the World of Doom. I have the fiber on. Let me refresh that one and see if that helps. Nope. Oh, it's buffering on Sylvia's. Okay. Hold on.
is the video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard drive.
Okay, so that's what y'all been doing, is using a hard drive?
We've done both, and
Okay.
that's what happened.
All right.
All right.
What are we going to be doing right now?
Setting.
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen. What is this? What is this? Transcript. Which one are we targeting first?
The one on page 90.
Okay.
I'm just trying to get. So where we are, the line he's at right now is the line 25 on page 89.
Okay.
So if I may, I'll just.
Sure, that's fine. Yep.
Dang, Slug, just take care of him. So Slug ain't go on the bus? No. When I told you, he grew up, he like, he got J, he grew up, he on that no more. But you said Shannon. How Shannon get involved in everything? So when they hear him speak, it's almost like call Shannon. But that's what it says because Shannon too. Now, Shannon always be quiet. Right. He did. Yeah. He's scared. He should. When it comes down to it, he's not scared. Who shot Shannon? Who shot Shannon? They say he smoked. I don't know. I walked up.
All right.
Just jail. I read through jail.
I heard what I need. Okay. That's definitely a question. Shannon the shooter? And then the answer is no. He was quiet. So 17 is fine to be in.
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking who is the they that they're talking about? And I was just gonna maybe listen a little bit in front of that. But then, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is, or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Priscilla, have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers our on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so okay. All right, that takes us to 92, line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay.
So okay.
So it's not the entirety of 92. That's just to give me context. Is it when, is it 93 line 21 where the real objection starts? 92 line 15. Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Matthews, bring around the corner. Just bring around the corner.
Thanks.
Yeah, it's right this way. That's good.
Okay.
So investigator Dennis was present. He was working an extra job at Club Compound And he's already testified, and he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused, and he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get Investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me on page 92, is there anything? Well, I guess line 15, like
right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kaikendo, and he's actually wrong about that. Fatty is Kaikendo. And so he's just kind of setting the stage of the people he saw. And then
starting at where? 15?
15.
Okay. Yeah.
And then he's talking about the gun that DK had a gun and he recovered the gun and how he pulled out his gun, and Jeffrey's sister Max took offense to it, and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day, and I just don't think it's appropriate for it to be played in an out-of-court statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relating and receiving input from Mr. Zachary, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Page 93, line
15 through 17, for instance. Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Sharp said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are.
Well, let me.
Or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, so we'll redact that by agreement.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93. Lines 3 through 9.
Okay, so that you believe should be in. All right, and
that's because as Investigator Dennis is talking about cooking dog fatty and DK being like this, Mr. Zachary is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and, okay.
That's our position.
All right. Any response on the 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine with
right,
that.
so that is then in by agreement, essentially. All right,
As we go on further down,
and then
I have no objection to 19 through 23 coming out, where Investigator Dennis is talking about cooking dogs. Not cooking dogs, but DK's gun having been taken.
right, okay. All right, and so up above then, where he's saying DK had a gun, I recovered a gun, yeah, I saw that. Is he literally mean, yeah, I saw that on the scene?
Yes.
Okay, yeah, that seems like that could come in. All right.
So lines 24
Mm-hmm.
and 25 on 93 lead into
Mm-hmm.
page 94, lines 1 and 2.
Okay.
We would object to that coming out.
Yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6.
Actually,
3 through 7.
well,
Or
yeah, 3 through 7, that's fine.
Okay.
Look, line 8 through 10. In, we would object to that coming out.
Okay.
We would object to line 11 through 18 coming out.
Mm-hmm.
We don't, actually, we would object to line 19 through 25 coming out as well. Specifically, where only that Detective Dennis said lines 19 through 22.
Right.
But then Mr. Zachary gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Sharp?
No, Your Honor.
Okay, all right. I'm going to permit that in.
And so
is everybody clear on what's out and in, or do you want me to? Good.
I'm clear.
All right.
So the next section, Your Honor, is kind of picks up right where we are. And I flagged this because it was unclear to me at the time whether Mr. Zachary was claiming that he was there, but I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't,
Okay.
what is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with them. With who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters. And Quindarius Zachary says, yeah. He wasn't present for the shooting.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who wasn't present, saying
Right.
Pee Wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay. So I think essentially that one is, okay, this is the law enforcement theory at this time, but
So we're starting on
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way, for open to reserve the right. If I ask that the court allow, if we are able to establish that foundation, then I'd ask that the court not exclude it.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it.
Okay.
Or some other.
Okay. Or, okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also say, so with respect to Mr. Zachary, he has, and the reason we have some TBDs by some of this is that he has not been the most cooperative person. And I just leave it.
Okay. All right, so we'll just see on that. I understand the objection. I understand that it can't actually quite be answered yet. There's a foundational issue. We'll just have to see. Okay. So then we've got, I guess, what? 6 through 14.
I don't have a problem with lines 6 through 8. But then again, he starts theorizing about who's a shooter and who's not. And he says Troop wasn't no shooter. He was there though. I think he was following them too.
I don't have an objection to, is it 9 through 13?
Yeah.
I don't have any.
Okay.
And then I have a problem with 14 through 22. 14 through 25, really.
And is that same basis, like, how does he know this?
Correct.
Okay. Is that also by necessity TBD based on your frustration with your witness? Okay.
And
Well-
that leads into, 96 as well.
Well, I would say 24 and 25, 95 lines 24 and 25 to 96 is really, 96 line 14 is all speculation about why Jimmy Winfrey pled guilty. I don't think that's TBD. I think
Okay,
that
all
would be.
right, so
completely
hang on, we've got, I'm sorry, maybe I'm just not up with y'all. So 95, 14 through 23 is TBD, is that right?
That's correct, yes.
And then when we start on 24, line 24 and going on, okay. This. Yeah. I mean, so the objection is on page 96, what lines?
I don't have an objection to 96.
95 line 24 to 96 line 14.
I don't have an objection.
Okay.
So now, not that many hours before my flight leaves, I got a message that there has been some delays and changes. I need to take care of that. So you probably won't see me here because I have to take care of that. I will keep streaming this until the end, but just for your information. So I will not mind if you pop over to Cat Not Williams or anybody else who streams this, but you will probably not see me on this stream. Maybe I will say a few words at the very end of it. Okay. See you in a bit.
Out by agreement. Okay, so are we now at number 29?
Yes.
Okay. Uh-huh.
So, Your Honor, the context of this is there's a gentleman named Rico Rich.
Mm-hmm.
Is it Rico Rich or Rico Rich? Rico Rich. And he ran or owned a studio on Metropolitan that allegedly was also used at times by Mr. Williams.
Mm-hmm.
And at some point, this studio was raided, and marijuana was located at the studio, and I think Rico Rich was charged with it. It was his studio, my understanding. July 15, 2015 is when that raid occurred, and it has nothing to do with this case. And so they're just talking about Rico Rich being upset because his perception that the attention drawn by the gentleman in court led to the raid, and it's just about something that has nothing to do with this case.
All right.
And Judge, if I can just add to Mr. Shart's
All right.
position, the state, we've actually addressed this previously. The state agreed that this would not come in.
Okay. Well, we'll find out what Ms. Love says about that. But I think that maybe Ms. Love hasn't had as much of a chance to study this in detail as she would have liked and as I would have liked. And so, Ms. Love, is that correct that y'all had already agreed that this part needed to come out?
And by this part, what meaning?
99 line 18 through kind of, I guess, what, maybe all of 100 line 10.
Just 1 second. So I don't have an objection.
Okay.
To page 99, lines 18 through 23. And I don't have an objection to that.
Okay.
It continues on to page 100.
Yeah, go on to the next page through about line 10. It seems to be the same topic.
So we don't have any.
Frankly, 14, I think, or 15. Right? I mean, isn't that all the same?
15,
Okay.
Right.
All right. And so that would also encompass 99 line 24, which I think we accidentally left out of there. So, all right, by agreement, all the way through 100 line 15.
So that would be 99 minus 18, 24, all the way into 100 up to line 15.
Right. All right.
Now, Your Honor, if I could go off the list for a second, I believe
Sure.
one of my co-counsel has a objection to page 100, line 20 to 101, line 5. It talks about Jeffrey's family, how he likes to be in the hood, and he likes people that are going to be right there with him, same people he grew up with. And then investigator Dennis says, right, that makes you guilty by association, and that's improper. And then they talk about Mr. Bennett's aunt being shot.
Okay.
So, Your Honor, the state has no objection to page 100, lines 24 through 25, but we would ask the court to listen. I think I have a different take on lines 20 through 23 than Mr. Sharp. I don't think he's talking about Mr. Williams' family so much.
He's saying though, I'm saying though, Thug is family. He likes to, yeah, okay. I can listen to it. Do you want me to listen to it right now?
Regardless, it says he's hanging out with the same people he grew up with, and then investigator Dennis improperly.
Oh, yeah, no. She
Yes.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then, so 100 line 24 through 101 line 4 are out by agreement.
And then at 101.9, they start asking Mr. Zachary how he would feel if his mother got shot while she was asleep in the bed and all of those things. And I don't think that's appropriate either.
So Judge, based on the court's ruling regarding 1 through 4 up through 11 would be okay?
Yeah, all right, well, you agreed with it.
I
All right, so all the way through 101 line 11. Thank you.
I mean, it continues beyond 11.
Okay,
It continues.
yeah,
But Judge, with
Yeah.
respect to the ones after 11, Mr. Zachary is saying his expressions, I believe, are relevant. I don't think that is the same
all right.
as 1 through 11.
And when you say his expressions, then you mean like facial expressions when
No,
he's
no.
talking, or what do you mean?
What he expresses, they just shot up my cousin's house. I'm mad, and I don't disagree with respect to
Yeah, I think it goes to.
line 20. I don't mind all of that up to line.
Okay, so now we're to 101 line 20 out by agreement.
Judge,
Yes.
if I may, the conversation continues on. It's this well beyond 101. I don't think reference to that incident ends until we get to page 102.
So maybe through line 8
I was thinking 18.
or 19.
Yes.
Okay. Yeah, I mean, yeah, essentially they're saying bad things happen. How would that make you feel? And he's not saying anything other than maybe how he would feel, but that's, you can feel whatever way.
Right.
Aren't these kind of hypotheticals? All right, so through 102 line 19 out by agreement.
Now, the next section.
So the next objection, okay, so that's carried us through 30 and 31 then, okay, right?
Yes.
All right, so we're now on item number 32, which starts on page 104, line 3, and goes to the next page, line 3.
And this is involving the Donovan Thomas case. And
Yeah.
I will say that in the other statement, Mr. Zachary asserts that Mr. Stillwell and Mr. Kendrick made some sort of statements against their interest
Okay.
as to who was in the car. But he never asserts that they told him about these details, and he's never claimed that he was there on Cleveland Avenue when he talks here. He's talking about a gentleman named Kelvin Treadwell, also known as OG Bentley, basically taking the guns and taking the car and disposing of those things. He never claims to have been there, and I don't think anyone's claimed he was there. He claims he was at a kid's party, and I think the state has accepted that. And he's never said that he got that information from Mr. Stillwell or Mr. Kendricks, and I don't know where he's claiming he got this information from, but until that is established, I don't believe that it's admissible, even as a prior inconsistent statement, hypothetically.
So, Judge, what Mr. Zachary said in his prior statement is that he got that information from two of the defendants on trial now, following the shooting at one point the night of at Mr. Williams' condo, and I believe the next one on the way to Miami. My memory may be a little bit fuzzy on that, but because he corrects one of the detectives when they're saying, so both of them told you at the condo. And he says, no, one told me at the condo, the other told me on the way to Miami.
Okay.
So our argument is that his recitation of what happened would have come from, he wasn't there, we've never said he was, would have come from the same place that he was made privy to the statements that we caught nuts down at, which was at the condo, on their way to Miami, because they were together. And by they, I mean various members of YSL. They didn't all go in one car together down there, but they traveled to Miami in the days after the murder. So
Okay, but this is about Bentley's potential involvement in getting rid of the guns, is that right?
So OG Bentley is alleged to have, yes,
Okay.
gotten rid of the guns after the murder.
Okay.
And our argument would be that Mr. Zachary would not have, he's not the only one that says that. They wouldn't, this collective knowledge wouldn't exist, but for his involvement in the gang itself. So this is another spot where I would say, where I would object to it coming out. But of course, I'm going to follow whatever ruling the court makes.
All right.
And I just want to be clear. I actually agree with Ms. Love's recitation of facts to the extent that he said that he got certain information from those individuals, but it's not this information.
Yeah, I mean, it does seem like, I mean, he could legitimately have gotten the information about two other people saying they're involved, and that's one thing, and that's not what this is about. This is about what was OG Bentley's involvement, and did he, get and hide guns? And literally, even on 104, like towards the bottom, and they're asking about, they gave him the guns. He's like, that's what I hear. He doesn't even seem to be saying, hey, I know this from one of my in-gang sources. He's just like, oh, I mean, I don't know.
In the 2015 interview, a little bit more detailed and a little bit more statistics. He references it. So at the very least, I think it.
All right. So how about if you can point me specifically to where in the 2015 thing it shows that he actually has the legit knowledge of this, then I'll reconsider it.
Okay.
Okay. All right.
So I'm just gonna put, okay, contingent on.
Yes.
And this would be all
basically 104 line, what? 103 through 105, line 3. Is that right?
Yes,
Okay.
104.3 to 105.3.
All right. So moving on to item number 33, which is a little portion of page 105.
So the state has no objection to 11 through 14 coming out.
All right. All right. So that takes us to page 107. Our first
I'm gonna withdraw that one.
34.
Yes.
Okay. And how about 35? We're still gonna sort out.
35?
Yes. Item number 35, which is 107, line 23 through 108, line 1.
I didn't remember talking about that one.
Well, it's in your list.
No, you said we're still gonna.
No, I'm asking you.
Oh, yes.
So that's what we're moving to next, right?
Yes.
Okay. Sorry.
I thought
like,
you were
wait a
saying
minute.
we had already discussed it. I got you.
No. Okay. All right. 107, line 23.
Just a random discussion about a fight in a club that Mr. Kendricks allegedly got into with a man named Lil Tony.
Okay. Does that have anything to do with this case?
What did he have? No, it doesn't.
All right. Thank you, Mr. Shard. I'm asking the state now.
So actually, Judge, going back to 106.
Okay.
So 106 just gives sort of context of the time frame, but from 1 to page 107, line 1, when Dennis is asking.
Right. Is this about the time the beef's kicking off? Okay. Well, they don't have an objection to that.
So it's going back to the gambling house shooting, and they thought the quote unquote the mob did it, but then we find out that apparently Kelvin Watts pillow talk with a young lady led to it being revealed that Kelvin Watts did it. And essentially they're asking, why did you think the mob did it? Why did you mistakenly think the mob did it? Assume. And they're saying, oh, because Mr. Kendrick beat up one of them named Lil Tony.
Okay.
And so I don't know why.
Okay.
And this is all around as Detective Dennis said, this goes back around, this is all around the time that
Right. So as I understand the objection, it is to, well, it may be a little further up than line 23, right?
It really starts on 14. Why did you think the mob was
All right. So starting at 107, line 14 through 108, line 1.
So when Detective Dennis asks Mr. Zachary, why did you think the shooting was taking place? And Mr. Zachary is telling Detective Dennis, yes, he might be speculating about why they did a rival party did what they did, but he's also stating that Diamante Kendrick had just beat up one of them.
But this isn't, I'm sorry, it just for my clarification, this isn't one of the IF people. This is some other group, right?
Where it says why y'all thought tomorrow and then
Phonetic or
phonetic,
something.
right there on line 14.
Right.
If you listen to it, it says why y'all thought the mob was shooting, not tomorrow.
The mob?
The mob.
Okay.
And that's the gang that they assumed.
Okay. All right, so why do we need this? What is your position as to why this would be admissible? Line, 14 through the next page, line 1. Hey, man, I mean, we thought for a while it was this other group because of this other beef that had gone down.
So as it relates to 14 through 17, we would stipulate to that. But my 18 where Detective Dennis says y'all had beef all over the place. Y'all being his acknowledgement as he was
Okay.
to Zachary of them as a group.
Okay. And Zachary at 21 says, yeah.
Yes.
Okay. So then 18 through 21 seems like that legitimately could come in. And then that brings us then to 22 through the next page, line 1, about, okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in. Because it seems like 20, you're okay with that?
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line on the next page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Sharp? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we're moving to line 23.
Yes.
I have no objection to 23. I have no objection to 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no,
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know. The last time we talked, they were talking about
Somebody
Nut
else.
and Greedy and
Okay.
Kel being half brothers. And
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay.
You know, if the state needs to play 14 through 19, I just say play the whole thing and
Okay.
give context.
All right. So then that actually starts with 109 line 23 or no?
Yes.
Okay. All right. So basically they're withdrawing their objection to that. Page 111, lines 7 through 9. Okay. What does the state say as to that?
that Mr. Zachary's response, no, Thug just stopped messing with Booty. And the subsequent lines are important evidence in this case. Obviously, Booty is Mr. Copeland. He's the one on the stand right now. I can't, you know,
Yeah. No, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question.
It's not a question, though.
Between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well, it
of it.
says,
I mean,
word I got is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and even if they had, that needs to be come from the stand.
He starts out with how did Shannon.
yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Thug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody in?
That works. Thank you. Thank you.
Thank you.
One 13 line 20 through 114 line 3. So do y'all, before we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But there are how many? Two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, I mean, some of this I am having to make rulings on, but a lot of it, it's like, It might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time, by which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now. So can we sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on?
I have no problem with that. I know
Thank
that
you.
Mr. Sharp was endeavoring to give us another.
He's got, this list is great because I just need, okay. I need the responses to winnowed. All right, great.
Okay, he gave us to us from one of the other interviews. We need the last one. There's 3 of them.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these 2, he can be finishing the 3rd one, if he doesn't have it yet.
I'm trying to remember. I'll talk to the state afterwards. I want to make sure I'm on the same page with them about the 3 different statements.
Okay. So I'm sort of thinking I don't want to do any more of this. How about that? Because y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
John, we do the open court exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I'm kidding. I understand this is a monumental task, which again, should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're going to be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems reasonable. All right, what else?
And also, the court asked us for, at the beginning of the week, to have the next.
Yes, the next tranche. Yes.
Yes. So
Where are we on that?
we count, even that tomorrow night is the end of the beginning of the week, but I don't know. So we're in there.
You're okay. All right. I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely. Yeah. I mean, but we got to have something to at least start with. Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with Mr. Copeland, which may not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning. But I'm gonna have, that'll be, I mean, it's gonna be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as well, since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agreed to it.
Your Honor?
Yes.
I thought the people charged here position was, and I think the state's position was just to include the 7th, which really was not anything, and then the 10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity fully and correctly informed to make a decision about whether to testify, then if he says, no, I don't want to, throw me in jail, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, an odd scenario.
If we don't get to cross-examine Mr. Coburn, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that of course comes with risks. So it just, a lot of this is up in the air depending upon, I think if he says now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So, but anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with. So, so y'all be thinking about that.
Did Your Honor get the thumbs up?
Yes, magically. All right. Anything else before we break for the day early? Because I'm going to go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of.
Okay.
Where an expert, he's already been qualified. His name is Agent Bernie, B-E-R-N-I, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice. And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Miss
Yes. So the new phone number is, there was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with some of the alleged parties to the crime. Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder.
Oh, hell no. Oh, hell no. In the middle of the trial, she claims now, without any foreshadowing or anything, that investigators have found another person in that car that hasn't spoken up in 10 years. Oh, hell no. Oh, hell no. I hope to everything that is holy that Judge Whitaker says, so sad, too bad, too late, bye-bye.
We got it before now, but we got it after the trial began, like between, I think, January and now. And I think
between January and now. Oh, hell no. If you had this information in February and didn't disclose it until now, August 5th, then the defense should make a motion of off you fork.
I think it was inadvertent that it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The report from the investigator, from Detective Bernie, involved.
Isn't it strange that the moment they discover, oh hell, our case is going down the drain, da-dum-dum, pow! Investigators found a new snitch. Sure, Miss Love, sure.
Plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two, because the green store is a thing that came up recently during trial, and the other location was. So we have two understandings of what the court is asking. So we're not talking about the plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
We're talking, I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
Hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
Boyer.
Boyer, okay.
On Monday, on yesterday.
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well.
Okay.
Which leads
Nobody
me to-
really, I'm sorry. Do y'all care? Is the objection to the charting or?
It leads me to believe that they've had them for a while if they've plotted them.
All right. So the plotting of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay. And y'all just recently asked for that based on some testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay. All right. So then let's back up to the original issue. When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know the answer.
Can you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently, like 2 days ago, was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that based on the phone records, this person was in it.
Okay, so when did they ask for, not we, but y'all or they ask for the phone records because they thought that might be?
I begged the court to allow.
All right, find that out. And then, do you know when y'all got the cell phone records?
When you said I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay, so unfortunately for you, we equals, y'all equals, the state equals both the DA's office and the Atlanta Police Department. You know that. And I know sometimes there's a little lag in communication, but I need to know, was it, if they were provided to the defense on Monday, was it last week or was it 4 months ago?
Okay, I can find
out. Because, okay.
Oh, no.
And
Manufacturer.
what do these cell phone records reveal? That this person did appear to be also in the car?
Yes.
And
There's two cars.
okay, do you know which car? I mean, there are two cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved?
The state
Okay.
is alleging that there's a white car with my client and Mr. Garlington in
Right.
it, and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars. And I'm inquiring what,
Mm-hmm.
I don't know anything
I'd
about
like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
Because it was not a part of the original. Yes.
Okay, how long has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, except for this, I could tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a jail call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing. I still, to this day, have no reports on it. I've never interviewed him. I didn't open on him. He could be a great defense. I have no idea who this person is.
Yeah. I mean, yeah, this is, I mean, you know, potentially significant information for the defense to know
Brady
about.
violation. Can
I
you
can't
spell
say that
Brady,
every
Ms.
time we
Love?
get opening that the police have it. I'd like to be able to say.
All right. All right, we'll find out. But there's been a long period of time between opening and now. 8 months to be.
That was 24.
More than 8 months.
7 or 8 months. So,
9 months.
we need a lot more information about this. I love how y'all save all of the like bombshells for late in the day, right before we're wrapping. Y'all like going, hey, guess what? So, okay. I mean, it is what it is. Okay. So we'll need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you also, I believe, we're going to get by tomorrow actual, like a list to the defense of here's what we think is a co-conspirator statement, right? Okay, so we'll be waiting anxiously for all of those. Anything else? As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Miss Love misspoke. Did Miss?
I might have put a date wrong, but I'm talking about 2015. I think it was August 2015. I believe March 2017 in the proper. So I'm sorry. I might have misspoken.
Okay, so you think that maybe there only are 2, but you'll confirm that for us tomorrow? All right, and so if there are only 2, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to 2 full statements, right? Or proposed redactions.
I have. I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the board needs to finish the court, just allow me to get this thing copied.
Yeah. Regarding how this trial have gone, I do not think they want to risk having statements from this person. I think they should just ask the judge to, Judge, they have had this information. They, as in Atlanta Police Department, the investigators, and by definition, the prosecution's team, have had this information since January. And that is information that should have been in the initial case, which it isn't. We don't know who this guy is. If say he's in prison and he wants to cut a deal, he will say anything. No, this is another part of, in my opinion, prosecutorial misconduct.
All right, that's fine. That'll work. Thank you.
I think.
All right, see y'all at
Yeah, I will be traveling tomorrow, so you have to find somebody else. I haven't found out. I haven't gotten an answer how I will ever be able to do the remote control thingy, and my flight leaves in 8 hours, so I will not have the time for it. I don't think they should allow anything near this, and I also believe they should argue towards the judge. This is just another example of prosecutorial misconduct. They have had this information since the beginning of this trial and not uttered a word about it until today, which speaks to prosecutorial misconduct. Disqualify them, mistrial with prejudice, something of the sort. Okay, folks, tomorrow is my travel day. I will try to film and post something to either this channel, but definitely on my road trip channel, which is pinned on the top of the chat. And now I have to finish packing and get a couple of hours of sleep because the cab will be here in 4 hours. And so I can get to the airport in time for booking, especially now since they have rebooked me from Delta to KLM. What a fun day. What a fun day. What more can I say than thank you? Thank you for being here. Thank you for allowing me to do this. Trying to translate with law and snark and everything in between for you. I hope I can, well, I hope you are actually entertained and that you know more about this case today than yesterday. But again, thank you. And, well, you know it. Hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. I will play another tune for you. I don't really remember this one, but it's something about my trip to the United States. See you around. Bye-bye.